profession. Let's begin today with clarity, curiosity, and the commitment that defines us as chartered accountants. Today, we deep dive into practical litigation skills in GSTAT with leading judges, advocates, and eminent professionals under moot court sessions. So we now request our chairperson, CA Revati S. Raghunathan and CA Dr. Abhishek Murali, RCM SIRC of ICA, to kindly accompany Advocate Karthik Sundaram and CA Jatin Christopher to join us on the dais. Okay, we'll raise up for the ICA motto song.
Yaesha supteshu jagrati Yaesha supteshu jagrati Kamam 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 kamarsho pursho nirvimana tadeva shukrada brahma Tasmin lokaha sarve taduna kaschanatyati kaschan etadvaita 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 etadvaita.
Yeah, we invite our chairperson, CA Revati S. Raghunathan, to say a few welcome address.
I normally start off with a very warm good morning, but today not being so warm, or rather a wet day, I'm just going to say good morning, everyone. And we are having a deluge outside, or rather hoping for a deluge outside. The prediction is a deluge, but we are very sure that today we are going to have a deluge of knowledge sharing by both Advocate Karthik Sundaram sir and Jatin Christopher sir. And I want to place on record my appreciation to both of them. Both of them were, so generous, and they didn't have anything to say. I said, sir, please, I request you. They said, okay, madam, definitely. Like, I mean, what I've realized over the past few years is, the higher you climb up in life, the higher you climb up the professional ladder, your humility is also directly proportional. And that is one thing which I have learned from my interactions with everyone. And the humility, with which both these two gentlemen interacted with me, and their knowledge sharing, and the way they accepted was, I was totally humbled by that experience. Thank you very, very much, sir, once again. And also, you all will be wondering, the whole of today is combination of chartered accountants and advocates. And I did get a few comments about you are overlooking the chartered accountants. I am not overlooking the chartered accountants. What I am trying to say is the synergies between the profession of advocacy and chartered accountancy is here to stay. We cannot operate in silos, and we need to hold hands, not even extend hands. We have to hold hands in our journey for professional excellence. And today morning, I read one headline. Modi ji said that Indian government will act like a Sudarshan Chakra. And I think that, we professionals are going to be the Sudarshan Chakra for all our clients. And you would have also seen another article where Mr. Vembu said, and Gen AI actually sent him a message giving him all the details of an acquisition for which the company had sent. A proposal was made by the MD of the company requesting Vembu sir to acquire the company, and the Gen AI actually sent an email with all the details of the transaction. So when we have such AI systems there, I would say that we can all be very, very comfortable in our professional excellence and know very well that our opportunities are not going to dry up. And in fact, AI is AI, artificial intelligence, and it's always going to give work for us professionals on a plate. So we do have MDP, sir, our to all the advocates here, multidisciplinary firms has been approved by the Institute of Chartered Accountants, but the other professional bodies have still not taken the step forward. But we have taken the step forward today. Unofficially, we both are going to partner, the chartered accountants and the advocates, and we are extremely grateful for all the advocates for actually accepting our invite and coming here today. And with that, I want to say that everyone who has come in early here today, a very, very warm welcome, because you would all been cozily tucked in at home, watching the rain, the breeze, the news item saying the cyclone is just 10 kilometers away and 15 kilometers away, and waiting for the information. But you've all managed to come here. I think that is in the expectation of the deluge of knowledge over here. So thank you very much, everyone, for making your presence here. Abhishek and I are extremely grateful to all of you for respecting the professionals who have come here. In fact, they came much earlier than all of us. So that was their eagerness to share their knowledge. Thank you, sir, and a very warm welcome to both of you also. And again, here I want to place on record my appreciation to K. Ravi, sir, who enabled us to bring all the top-notch advocates also. My invite was to Jatin, sir, and K. Ravi's invite was to Karthik, sir. Thank you very much.
Thank you, ma'am, for your warm welcome address. So to honor his presence with us today, I invite CA Dr. Abhishek Murali, RCM SIRC of ICI, to adorn the shawl to Advocate Karthik Sundaram. As a token of our respect and appreciation, invite Chairperson CA Revathi S. Raghunathan to give memento. As a token of our respect and appreciation, invite Chairperson CA Revathi S. Raghunathan to give memento to Advocate Karthik Sundaram and CA Jatin Christopher. We now invite Advocate Karthik Sundaram to address the gathering on the law relating to the writ petitions with special emphasis on tax laws. Writ petition serves as a powerful constitutional remedy to challenge arbitrary actions of authorities and protect fundamental rights. Profile: Advocate Karthik Sundaram has nearly 2 decades of experience in tax and commercial litigation, began his career under senior counsel Arvind P. Datar. He was also associated with Mr. Rohan Shah, presently a senior advocate based out of Mumbai. He served as a partner at Economic Law Practice, handling significant matters for major MNCs and large Indian corporates. He now practices independently before the Madras High Court, leads Karthik Law Chambers, specializing in indirect taxation. The first petition in any court of law on online gaming matters was filed by his able wife, Deepika Murali, who is also an advocate. His expertise spans GST, customs, anti-dumping, erstwhile indirect taxes, arbitration, corporate and commercial litigation, IBC, and RERA matters. He is the author of 2 editions of tax constitutions on the Supreme Court and has published several significant articles on taxation and constitutional law. Over to you, sir.
Thank you very much for the kind introduction. Thank you very much, Revathi ma'am, and thank you, Abhishek. Definitely thank you to Mr. Ravi for inviting you here. I was very pleased to hear what Revathi ma'am said about the synergy between CAs and lawyers. I think it is something very important and necessary for all of us. Also in the context of what the government is looking to create independent Indian big fours. If we see what is going on abroad, you have multidisciplinary firms. And I think the day is not far away where you will also see that in India. So I think we should really take off from what ma'am said. And just to add context to that, Mr. Ravi, who is here, is one of the leading CAs and lawyers today. The doyen of the tax on constitutional bar, Mr. Harish Salve, was first a chartered accountant and then he became a lawyer. Mr. Dattar today, he is a cost and works accountant and then a lawyer. Another leading lawyer with whom I work, Tarun Gulati, is again a chartered accountant and a lawyer. Therefore, really, in some senses, when you are dealing with tax law, chartered accountancy and law do go hand in hand. And that is also the reason for my topic today, writ petitions. Because writ petitions is not the pure domain of lawyers. I would believe even though chartered accountants do not appear in courts, the clients do keep asking them, can we file a writ petition? Yes, no. And increasingly, it is not can we file a writ petition. The questions sometimes are why are we not filing a writ petition? Therefore, given all that in mind, and also given that the GST Act, the Income Tax Act are all enactments enacted under the Constitution. The remedies which you normally exercise, being the statutory remedies, are remedies under the Act. The writ petition is a remedy under the Constitution. Therefore, as a chartered accountant, I believe it is very important that you have a very fundamental understanding of how the Constitution works insofar as tax laws is concerned. And one aspect of it is your remedies under constitutional law, which is what we are dealing with in the form of writ petitions. Therefore, what I broadly propose to do is rely a bit on the academic aspect of writ petitions and then correlate it to the practicality of writ petitions and what really happens in court. Because everything has an academic angle and a practical angle. Without the academic angle, it's very difficult to understand the practical nuances and vice versa. Just knowing the academic angle is not enough per se. Now, your nature of a writ remedy is, it is essentially a public law remedy for the enforcement of your fundamental rights and legal rights. The law says that judicial review is a basic feature of the Constitution. Writ remedies usually, there being some exceptions, are not a review on merits or not a review on the correctness of the decision. It is only a review of the decision making process. Now, if you really see this in action, in a lot of writs we file, the law per se is not decided. The substantive issue is not decided. What they really see is whether the principles of fairness, whether the principles of natural justice are complied with. If not, they send you back. If there is an issue with the decision making process, that is where the courts will normally interfere. A writ petition does not really go into the merits of the decision, because a writ petition is normally maintainable if there is a violation of natural justice, there is a jurisdictional issue, there is a violation of fundamental rights, in which case the court may give you a decision, or in some cases when it is a pure legal issue. The law is settled that if it is a disputed question of fact, a writ court will not entertain a writ, and most tax matters may involve disputed questions of fact as well as disputed questions of law. Therefore, it's important to really identify at the outset when you're filing a writ petition, what are you really looking at? Are you looking at a remedy where you want a decision on merits? If so, is it a pure legal issue, or is it a fact heavy issue, or are you looking for it to be sent back so that the authority can decide, or is it an action without jurisdiction, in which case you are seeking to enforce a writ, not to proceed. Now, when we are talking about writ petitions, we normally talk about Article 226 and Article 32. Article 226 is where a writ lies to the High Court. Since most of us practice here, 226 is what is most relevant to us. So, I will just go through the language of the provision, which will give us a better idea of the remedy. notwithstanding anything contained in 32, because 32 is your right to go to the Supreme Court. So just let's see 32. Remedies for enforcement of rights conferred under this part. Therefore, 32 is only for fundamental rights, which are enshrined in part 3 of the Constitution. As opposed to 32, 226 is every High Court shall have powers throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases government within whose territories, direction, order, writ, including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, or any of them for the enforcement of rights conferred by part 3 or for any other purpose. Therefore, what right can you enforce? You can either enforce a fundamental right, or any other purpose refers to your legal rights, statutory rights, as well as your other constitutional rights other than your fundamental rights. Therefore, what are the rights which can be enforced? What writ can you ask for? Habeas corpus, mandamus, prohibition, quo warranto, certiorari. These are the common writs, or you can ask for a writ in the nature of them or any other direction. I will come to what these individual writs mean. And against whom can you ask for? Any person, authority, including in appropriate cases, any government. Which court can be approached? Court will have power throughout the territories in relation to which it exercises jurisdiction. Therefore, which court can be approached and when does a court have jurisdiction is the next instance. So that is something I will deal with, and probably towards the end of the presentation, I will tie in all of this with how it works practically when you actually draft and file a writ petition. Now, 32 and 226, like I said, 32 is a remedy only for fundamental rights. 226 is much broader. It's for fundamental rights or any other rights, which is your legal rights, statutory rights, and other constitutional rights. Now, this is basically the difference between 32 and 226. I will not delve into this. Under 226, you have the right to issue what you refer to as your prerogative writs, which are extraordinary writs. Now, these are your remedies in the nature of a habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now, first I said if a fundamental right is infringed, normally in the context of tax writs, when you talk about infringement of fundamental rights, it's normally a right under Article 14, which confers equality before the law and equal protection of the law. There are some writs where people, as a matter of course, allege that Article 19(1)(g) or my right to do business is violated. Let me go into it a bit in detail, but at the outset, one major difference is Article 14 is a right qua person. Article 19 is a right only qua citizen. Therefore, while filing a writ itself, as a matter of course, a company files a writ and alleges that my rights under Article 14 and 19 have been violated. If I am asked a question, does a company have a right under Article 19? The answer is no. So this was dealt by the Supreme Court in a decision in Bennett and Coleman, and the Bombay High Court follows this very religiously. Other courts don't really get into it so much, but the minute Article 19 is there, the first question is a company a citizen? Therefore, what we do in such cases is we add a shareholder as a petitioner, as petitioner number 2, to say that the company is aggrieved and the rights of the company under Article 14 are violated. Insofar as Article 19 is concerned, I am a shareholder of the company, this affects me, and my rights as a shareholder and my right for the company to carry on business and therefore my right to profits as a shareholder are affected, and thus that is an Article 19 violation. Therefore, it's very important when you draft a writ petition not to just standardly say Article 14 is violated, Article 19 is violated. If you really get into it, you will necessarily have to do this if your question. Now, when we talk about an Article 14 violation, what is the law on Article 14? It's equal protection before the law, equality before the law. Therefore, when we are looking at tax matters, there is always a classification, be it income tax, be it GST, be it the erstwhile VAT service tax, because you can only tax people if you classify people differently. Not everything, not all transactions are alike, not all persons are alike. Your tax rates may be different. You may have a good, you may have a service. Therefore, in everything there is differentiation. Therefore, classification is a necessary way of life and commerce. But the classification, if done, must be based on some intelligible differentia and must have a rational nexus to the object of the legislation. That is essentially your equality before the law. Therefore, the law from 1962 has developed to say that if a tax legislation infringes Article 14, you can challenge it on the basis it violates the equality clause. The initial understanding of a challenge under Article 14 was only these two things, saying if it's a classification, it must be founded on intelligible differential. Now, let's take goods and services. Is there a difference between goods and services? I would say definitely yes. Therefore, if you have a different rate for goods and services, there is some basis. Now, let's take for agricultural commodities which are treated as goods. If I classify agricultural commodity A at 5% and agricultural commodity B which is similar to A, I keep it at 18% and I apply an entire different set of rules and regulations. Even though the law is that there is a lot of economic latitude in matters of taxation to the legislature, I think still we could really see whether the classification is based on intelligible differentia and whether it has a nexus to the object of the legislation. If the legislation or the policy behind it also says we want to treat all agricultural commodities equally and we want to follow the same rate as also the pattern of legislation qua agricultural commodities, then if you have 5% for one commodity and 18% for other, then you will get into a question. Is there an intelligible differentia? Your answer may be no. Does it have a nexus to the object of the legislation? Your answer to that may also be no. Then does that give you a ground to file a petition under Article 14? Possibly yes. So that is how the law was evolved. Then they said we'll have to look at the question of discrimination, whether the law is discriminatory or not. The law until 2017, I won't say the law has always remained the same. I would probably say more the understanding of law was that your challenge under Article 14 was also confined to say your equality before the law or equal protection of the law was more understood as being, is there intelligible differentia? Does it have a nexus with the object of the legislation? Then came the Supreme Court's decisions in the Sharia Banu case, which is in the context of talaq, and the Puttaswamy case, which is in the context of privacy, where the court said that within Article 14, you also have the principle of manifest arbitrariness. This is the court had said this previously in 1980 itself, but then it was interpreted as not being a facet of Article 14. But from 2017 onwards, the court repeatedly has emphasized that manifest arbitrariness is also a facet of Article 14. Therefore, if something is manifestly arbitrary, that itself is a ground for you to challenge the legislation. Now, they have said what is manifest arbitrariness? Something done by the legislature capriciously, irrationally, and without adequate determining principle. Also something which is excessive and disproportionate. Now, let us really break this down. What is done by the legislature capriciously? Capriciousness really means you are attributing intent to the legislature which frames the law, and says that the legislature has really done something mischievously or with a malafide intent. Now, on this I have some difficulty, because the settled law is that if the legislature has done something, it has done it with a good intent. You cannot attribute malafide to the legislature. Therefore, saying the legislature has done something capriciously, when the presumption in law is that you can't attribute malafides to the legislature, doesn't really seem something. So, I think to say that the legislature has done something capriciously, unless you are able to show something from parliamentary debates that they knew they couldn't do something, but they still did something which was not legally permissible, I really don't think this is a ground which is available in the normal course of things. Even if it's available, the threshold for meeting this will be extremely high. Irrationally, without adequate determining principle, something which is excessive and disproportionate. Like all things in tax laws, I think these are very, very vague and very broad. It does help lawyers in one way, because the broader and vaguer it is, the more things we are able to fit in. But when you say I interpret tax laws strictly, then my grounds of challenge also I think should be probably more fairly well defined or more fairly known. But this has sought to be interpreted in further decisions of the Supreme Court. This is your electoral bonds case, which is your Association for Democratic Reforms, where they have sought to explain provision lacks an adequate determining principle if the purpose is not in consonance with constitutional values. Now, again, extremely broad. What are my constitutional values? Is it confined to something flowing out of my fundamental rights? Is it something dealing with the basic structure of the Constitution? Or is it something dealing with any of the rights conferred under the Constitution per se? Provision is manifestly arbitrary. This probably is important, even if the provision does not make a classification. The previous understanding of the law is if you make a classification, then you see whether the classification is correct or not. Today, let us say that agricultural commodities and premium cars are treated equally, taxed at the same rate, same law is made applicable to them, but something akin to an agricultural commodity, which is a processed product arising out of agriculture, is treated differently, has a much lower tax rate, has a different set of rules and regulations. Then for not making a classification, can a writ lie? I think that question will seriously need to be gone into, and probably a writ will lie. After this explanation, saying not making a classification is also something which is manifestly arbitrary. Manifest arbitrariness of a subordinate legislation has to be primarily tested vis-a-vis conformity with the parent statute. Now, for all of us tax lawyers, this is something extremely important. You have the Income Tax Act, you have the GST Act. That is your parent enactment. The rules themselves are subordinate enactment. Most of our regulation is done either by amendment to the rules or by issuing notifications, which are in the nature of subordinate legislation. Now, in addition to the primary principles, my subordinate legislation should also be in consonance with the parent legislation, which is the CGST Act if I am dealing with GST, either the CGST Act, the SGST Act or the IGST Act. Many of you may have a question that all of these seem concepts dealing with electoral bonds, concepts dealing with privacy. How do they have relevance to tax laws? Simple answer is this. Article 14 applies to tax laws. Manifest arbitrariness is a facet of Article 14, and the court in fact applied it to tax laws specifically in the case of CIT versus Pepsi Food. So this was the case where you had an automatic stay, and the court before the ITAT said that your stay will expire after 365 days. The court went into the practicalities of the situation and said that one may be a situation where an assessee, after getting a stay, is trying to ensure the matter doesn't get heard by taking repeated adjournments. 2 may be a case where the bench doesn't sit, where given the number of matters, the case is not taken up. So how can you say that someone who is ready and willing to go ahead with the matter, his stay will get automatically vacated because the court does not hear you, or the court is not able to take up the matter? Can an assessee be affected because something not within his control, that is the functioning of the court, and his stay get vacated? They said no. You really can't have a thing which draws everything with the same brush. There necessarily has to be a classification. So this goes back to the previous thing. Provision is manifestly arbitrary, even if the provision does not make a classification. There has to be a classification between genuine bona fide cases and cases which the assessee cannot help. Therefore, manifest arbitrariness has time and again been applied by the Supreme Court to cases of tax laws, and courts, the high courts are also applying them. Article 19, which is your right of a citizen to carry on trade, profession or business. Question arose in 63, whether the very fact that I levy a tax on a business, can I say it's violative of my fundamental right? Because I have a right to carry on business. By levying a tax on me, you are violating my right. Court said no. The levy of a tax is not such a restriction on your business that it violates your fundamental right. The object of a legislation is not to prevent the dealer from carrying on business, but it envisages that the dealer will carry on business, let him carry on business on a larger scale, and so that the state might earn some tax. Now, whether tax legislations actually facilitate or don't interfere with carrying on business, that's a question which many of the business owners may have to answer. In fact, when GST came, a lot of people told me that for the first 3-4 months I didn't carry on business. I was only complying with GST, and only after that I started carrying on business per se. The second again is taxing statutes per se are not a restriction on the freedom to carry on business under 19(1)(g). Now, this is a summarization of your principles. I will not really go into it. The principles set out in Rakesh Kohli are quite important. There's always a presumption in favor of the constitutionality of a law made by Parliament or a state legislature. Why this is important is when you go to court, the presumption is that a provision is valid. Therefore, if I as a lawyer come and tell you, no, law is invalid, please challenge it, the threshold which I have to meet is very high, but because the legal presumption is in favor of constitutionality. Therefore, courts will be very slow to strike down a provision. They will first apply the presumption saying the provision is constitutional. If not, they will then try to read the provision in such a way to see whether they can interpret it in a manner which is constitutional. If not, there is a legislative device of reading down, where they will read down the provision to make it constitutional and not strike it down. And number 4, if nothing works, then courts will strike it down. Therefore, striking down a provision is only stage 4. So, if someone comes and tells you that no, it's unconstitutional, we'll challenge it, it will be struck down, answer is no. These are the 4 stages which courts will have to see, and only at stage 4 will they strike down a provision. Therefore, before mounting any constitutional challenge, you will have to know the law, understand really what will happen, understand that at stage 4 is when it will get struck down. I am not suggesting against constitutional challenges, those are the bread and butter of every lawyer, but as a CA, as a litigant and as a lawyer, you should really know where you stand so that you give a very fair and correct assessment of what is going to happen. No enactment can be struck down by just saying it's arbitrary or unreasonable, irrational. Some constitutional infirmity has to be found. This was a decision in 2012 that is no longer good law after the decision in Sharia Banu, where the principle of manifest arbitrariness has been applied. Therefore, I don't think 2 can be there. Court is not concerned with the wisdom or unwisdom, justice or injustice of the law, as Parliament and state legislature are supposed to be alive to the needs of the people whom they represent. They are the best judge of the community by whose suffrage they come into existence. Therefore, when Sharia Banu said that manifest arbitrariness is capriciousness of law, I have my doubts because the threshold is extremely high, and the law is that you can't attribute motives to the legislature. If you take your Income Tax Act or you take your GST Act, provisions towards the end which no one reads, you will have provisions to say that any act taken by the officer is presumed to be in good faith, and you cannot question the intent of the actions per se. All that weaves in with the scheme of the legislature to say you can't question the intent of the legislature, you can't question the intent of the officers who are implementing the legislation, and all acts are supposed to be done in good faith. Hardship is not relevant in pronouncing on the constitutional validity of a fiscal statute or economic law. Therefore, can I really come up and say it's very difficult for me to comply with laws? It's taking me away from the business which I want to do? Answer is no. In the field of taxation, legislature enjoys greater latitude of classification. So, those are the general principles relating to a challenge to a provision, when it can be challenged and how it will work, and 14 and 19, because the first part of Article 226 is violation of fundamental rights. Another aspect is legislative competence. Today, given the limited time, I don't think I'll be able to touch on it, but legislative competence as a concept essentially is that the legislature making the law should have the competence to make it. Competence flows from Article 245, 246 or 246A of the Constitution. The entries under the Constitution are wrongly understood to give legislative competence. They don't give legislative competence, they only demarcate the domain or the limits of legislative competence, which flows from 245, 246 or 246A of the Constitution. We issue writs in the nature of habeas corpus. Habeas corpus essentially is a remedy against illegal detention, restraint. Habeas corpus itself is a Latin term saying for produce the body. Therefore, when you are dealing with writs of habeas corpus, essentially you are dealing with Article 21 of the Constitution. In tax laws, it is not so relevant. The extremely limited matters where people are now trying to apply habeas corpus is when you are having investigations. When you see people confined for over 24 hours, people have started filing habeas corpus saying it amounts to arrest without actually following the provisions of arrest. Therefore, produce the person. So, I have seen some criminal lawyers file a writ of habeas corpus, and what that does is stall the investigation so that the person can come out. Therefore, in those limited number of cases is where I have really seen the applicability of habeas corpus when it comes to tax litigation. Mandamus, very common. Refund not granted, file a mandamus directing him to grant a refund. Not decided within a certain period of time, file a mandamus to decide within a certain period of time. But thankfully, in many legislations today, you will find time limits prescribed for adjudication. Therefore, what previously we used to file saying that mandamus for him to decide, instead today we are filing a certiorari or a prohibition to say that there is a time limit prescribed, he has not decided, therefore the proceedings he can't continue, quash the proceedings. Prohibition to confine the courts, tribunals of inferior jurisdiction. Prohibition and certiorari, I will just deal with it in detail. Quo warranto is basically an inquiry into by what authority a person holds office, not very relevant to tax matters. Certiorari to correct the error made by an inferior court or tribunal. Direction is or declaration is to challenge the virus of an act, legislation, or for a mere direction to do something. So, habeas corpus, I think I have pretty much dealt with this. Now, certiorari mandamus, certiorari prohibition. These three are the most common writs when we refer to a tax writ challenge other than a challenge to a legislation. Certiorari is to quash an order. Mandamus is to direct a public authority to perform his duty or forbear from doing something. Therefore, there is an overlap between mandamus and prohibition, because you can ask for a mandamus to positively compel an act, on that there is no overlap, to forbear him from doing something which he ought not to do. So, in that there is an overlap between a mandamus and a prohibition, because a prohibition also is trying to forbid an authority to do something which he cannot really do. There is a very nice article recently in Bar and Bench by Mr. Dattar, because normally even for a show cause notice, we file a writ of certiorari saying quash the show cause notice. For an order also we file a writ of certiorari to quash the order. If the issuance of the show cause notice is without jurisdiction, then the appropriate writ to file should be a writ of prohibition, not a writ of certiorari. Because when we come to the law relating to writ petitions, alternate remedy is a very important thing. If there is an alternate remedy, courts per se will not entertain the writ petition, and there is some law to say that when you ask for a writ of prohibition, saying that the authority does not have jurisdiction, alternate remedy is not a bar. This flows from the minority view in Bengal Immunity Company, as well as from the view in East India Commercial. Please do look at that article. I think Mr. Dattar every week writes something on legal notes in Bar and Bench. It's a very crisp, nice piece. But even law practitioners who have been there in the High Court for quite some time, even me, for instance, I have been filing certioraries to quash a show cause notice. It has made me sit back, think, have I been doing the right thing? Is prohibition actually not better? Because I don't really come across the bar of alternate remedy. Importance of pleadings in writ jurisdiction. It's an extraordinary jurisdiction. It's a constitutional remedies. Therefore, I should have clear, specific pleadings. Court will not assume facts. Court will not go into facts or disputed facts. Material facts, I should be very clear saying these are my material facts. Court will not go into evidence, but I should give them enough material for them to know what the issue is. Court cannot grant relief on vague or general allegations. Normal law is that I can't introduce a new ground during pleading. If I need to say something, it should be on affidavit. If I am alleging saying prejudice is caused to me, there is something illegal, it's without authority, I should clearly demonstrate that in the writ petition. Last and most important, petitioner should approach court with clean hands and disclose all material facts. Time and again, courts frown upon the practice where facts are not disclosed. Courts listen to about 60 matters a day. So, for an advocate it might be 1 or 2 matters, for a litigant it might be 1 or 2 matters. Courts do know the general trend, saying if this is the case, these will normally be the facts. Non-disclosure of facts definitely should be frowned upon. If there is something I need to disclose, if I filed a previous petition against the same order, can I approach the court once again after the previous petition being dismissed? No, I cannot. If I filed a writ petition on a similar issue, different assessment here, even if that's been dismissed, if I have a right to file it being a fresh assessment year, should I disclose to court that I have filed something for the previous year? It has been dismissed. I have filed an appeal against that. Definitely yes. That's a part of petitioner should approach the court with clean hands. If all of you want to read, there's a decision of the Supreme Court in Ramjas Foundation, which is in the context of a civil suit, but they said that the principle of approaching court with clean hands applies not only to civil suit, it also applies to writ petitions as also all proceedings before the court. On a lighter note, during COVID, someone had raised an issue saying that petitioner has not approached with clean hands. In one of the counter affidavits which was filed, someone had said, I wash my hands with Dettol at least twice every day, and therefore I've come to the court with clean hands. Definitely not a defense available in law. Reasoned orders. So when orders are being passed, why I am putting what the contents of an order is that your writ petition, if you are trying to seek for relief, should be drafted in such a manner that it is easy for the judge to pick what is available from the writ petition so that he can pass an order. So whenever you look at what an order should contain, basic facts, therefore it should be there in your writ petition. What is the issue where you are coming before court should be there. What are the submissions you are making should be there. Applicable law, yes. Now your writ petition is essentially an affidavit. There is one school of thought saying I shouldn't plead law on my affidavit. The other school of thought is that I should state the general principles which I am relying upon. I might not elaborate on it. I feel because you are stating your grounds, you can say on instructions, I am instructed to state that this is the law and these are the provisions on which I am relying upon. Reasons supporting conclusion. So if you want a good favorable order, 1, 2, 3, 4 are what needs to be there in your writ petition. Only if they are there can the reasons supporting conclusions follow. If 1, 2, 3, 4 are not there, it's very difficult for a judge. So you can't then say, oh, the order is not reasoned. Reasons are the soul of a judicial decision. Clear reasoning enhances legitimacy, accountability of the judicial process. Most important question. Alternate remedy, bar to filing of a writ petition. So, if you have an efficacious alternate remedy, courts will not entertain a writ petition. Does 226 anywhere say if there is an alternate remedy, writ will not be entertained? Strict legal reading, answer is no. Entertaining or not entertaining a writ is a question of discretion of the courts. It's a discretionary remedy. So, unlike an appeal which has to be taken up, whether to entertain a writ or not is the discretion of the courts. One of the things where courts will not entertain, which is judge-made law, is that if there is an alternate remedy. It is purely not judge-made law, because under the constitution you frame enactments. You have your Income Tax Act, you have your GST Act. Now your GST Act is a self-contained code, meaning if a show cause is issued, there is a provision for an order to be passed, there is a provision for an appeal to be filed. Therefore, if you have something which is strictly there, why should courts interfere? Courts, if they interfere when there is a right to appeal, are in fact bypassing what is governed in the statute. They cannot do so. Courts can pass orders in consonance with law. They can't pass orders not in consonance with law, which is why courts have come up with alternate remedy to say if there is a statutory remedy, ordinarily we will not interfere. What are the cases where they will interfere? Most important recent cases are Radhakrishnan, Magad, Harbanslai, Whirlpool. Radhakrishnan has summarized the principle. Can exercise 226 for fundamental right violation and other legal rights. If it's a fundamental right violation, I can't go under my ordinary statutory remedy. Therefore, the answer is a writ will lie. Other legal rights, that's where the question arises. If I am complaining a violation of a statutory provision under the GST Act, I do have a remedy under the GST Act itself. Therefore, whether or not the writ petition will be entertained or not, existence of effective alternate remedy is a self-imposed restriction, not a bar. It's not there in the law. They have imposed this restriction on themselves because they can't go beyond the statute. If it's a fundamental right, definitely yes. Violation of natural justice, proceedings are without jurisdiction, virus is challenged. Alternate remedy does not oust jurisdiction, but ordinarily writ should not be entertained. When statute creates a right and provides a remedy, that is, if I have a right to appeal, first exhaust it. May decline writ if disputed facts dominate. So, number 2, if you are asked, can I file a writ? Your answer shouldn't immediately be, someone else has filed a writ on this issue, yes. That may be one of the considerations which you take into account, but you will first have to see whether there is a statutory remedy. Yes, if there is a statutory remedy, will alternate remedy be a bar to me? Is there a violation of fundamental right? Is natural justice violated? Are the proceedings without jurisdiction? Am I challenging the virus? If I fall within any of this, then yes, go on a writ petition. If you don't fall within it, sorry, writ is a wrong remedy. If you are somewhere on the borderline, read more and then see which is a better remedy for you. Now, I had initially said that a writ court or judicial review is more about the decision making process, not the decision itself. Therefore, if you go in a writ saying violation of natural justice, court is not going to say fine, I will decide the issue. Court will say yes, natural justice has been violated. I will send you back to the authority. Let him give you a hearing and pass an order on merits. Therefore, it's important to understand that by going to court, I am not going to really get an opportunity for the matter to be decided on merits. It only happens that I am sent back and decided. Therefore, in a lot of cases, if there is a natural justice violation, should I just go to court and say send me back? Or should I actually pay 10%, 7.5%, go and appeal and have the matter heard if my future matters are going to be dependent on that, because a substantive decision on merits may happen quicker if I take the appellate route. We may have our own considerations saying that the authority may be revenue biased, so on and so forth, but strictly from a legal and strategic thinking perspective, it's not that if there is a natural justice violation, I immediately go and have to file a writ petition. I can still take a moment, think in the longer term of things, what will be more beneficial for the client, then give the clients 2 options. And why I am saying all this today is, as a CA, your client, it is no longer the case. Probably, I think 6-7 years back or even 10 years back, writ petition go to a lawyer. But for the last 10 years, at least from what I know, I am sure many of you may be able to correct me better, the CA advises the client, no, I think you should exercise the statutory remedy. I think you should go on a writ petition, we will coordinate with the lawyer. Therefore, for you to make this decision and for your client also to understand, it's very fundamental that you understand all this. What is a jurisdictional fact? Without jurisdiction, I can file a writ petition. Now, it's not enough for me to say act is without jurisdiction. I should understand what is a jurisdictional fact. It's a fact which must exist before a court, tribunal or authority assumes jurisdiction over a particular matter. Therefore, it's like a fundamental edifice. If this is there, they have jurisdiction. To give you a very simple example, if it's an interstate supply, can you levy a SGST? Answer is no. Only if it's an intrastate supply can you levy an SGST. Therefore, the fundamental question, whether it's an intrastate supply or an interstate supply, is a jurisdictional fact. If that is decided wrongly, that can give rise to a writ petition. Now, it is an intrastate supply. There is no dispute between that. In an intrastate supply, I said I have supplied 100 units. Department says no, you have supplied 120 units. Can I say that between 100 and 120 units, that's a jurisdictional fact? 90% of the cases, the answer will be no. In 10% of the cases, depending on the fact and situation, it might become a jurisdictional fact, but prima facie answer will be no for such situations. It's the fact upon which an administrative agency's power to act depends. If the jurisdictional fact does not exist, court authority or officer cannot act. If the court wrongly assumes, or the authority wrongly assumes the existence of a jurisdictional fact and proceeds, that can be questioned in a writ of certiorari. These are the two leading cases, Raza Textiles, Godrej Sarali. Now, in Godrej Sarali, the court has also held if it's a pure legal issue, shorn of all facts, court will still entertain a writ petition. Okay. Ravi sir has asked me a very difficult but interesting question. So, let me take a matter which we are doing, which got dismissed at the writ petition stage. So, this dealt with the issue of country of origin certificates under customs, and you have an India-ASEAN treaty which provides a particular procedure. Show cause notice was issued under 28 of the Customs Act. We took a stance saying that when a process is prescribed under the treaty, without following that and without setting aside the country of origin certificate, you can't issue a show cause under 28. Your jurisdiction to issue a show cause comes only if the country of origin certificate is set aside, and the factum of the setting aside of the country of origin certificate has to be as per the treaty. Therefore, whether you can issue the show cause or not is a jurisdictional fact. Matter was decided against us. So, when we have gone in appeal, the distinction we have drawn is show cause can only decide adjudicatory facts. Now, whether an authority has jurisdiction or not is a jurisdictional fact. If he has jurisdiction, then correctness of the allegations in the show cause notice, okay, whether in this import if I said 40%, whether it was 40% or 45% is something he can decide. Therefore, questions relating to a pure issue of jurisdiction are jurisdictional fact. Questions not dealing with jurisdiction, but dealing with the matter at hand are adjudicatory fact. The distinction in law is that for adjudicatory facts, I cannot file a writ petition. Only on jurisdictional facts, I can file a writ petition. Therefore, against a show cause notice, my personal view, court will still decide on that, is that if I can show it's a jurisdictional issue, writ has to be entertained. If they are able to show it's a pure adjudicatory issue, then writ will not be entertained. Distinction is if the authority can proceed with the show cause notice and he has to decide issues within the show cause notice, it will be an adjudicatory fact. Authority cannot proceed without show cause notice because he does not have the jurisdiction to do so. It's a jurisdictional fact. Therefore, one of the cases we have relied upon is Arun Kumar. There is one more case which I will send to you, which draws the distinction between an adjudicatory fact and a jurisdictional fact in law per se. Now, the other issue is some courts have held if it's a pure legal issue, I can go into it in a writ petition, alternate remedy is not a bar. Great ship, Article 226 is not meant to short circuit or circumvent statutory procedures. This is the interplay between the code and the statutory procedure. Even though there is an alternate remedy under the statute, some cases where writs are entertained, just to give you an idea about the interplay. If they tell me pre-deposit 100% of the tax, now my statutory alternate remedy is really negatory because I am paying the entire tax, they said writ will lie. Tribunal has already expressed a view on issue. I am against an assessment order. Now, if I go to an appellate authority who is between the tribunal and the adjudicating authority, he is bound to follow what the tribunal says. In such cases, courts held you can go on a writ petition because it's an empty formality. Natural justice, fundamental right. Competency, which is again a jurisdictional issue. Arun Kumar, jurisdictional issue. Order, lack of jurisdiction. Now, premeditation also of the show cause notice, which goes back to violation of the principles of natural justice, you can file it. Oryx fishery and Siemens are the important cases. Income tax, if you go standard case, Chabil Das Agarwal, alternate remedy, writ will not lie. It says where the Act provides a complete machinery for assessment, reassessment, obtaining relief, you cannot abandon that machinery and invoke the jurisdiction under 226. Remedy should be effective, it should not be a mere formality per se. Appeal from Caesar's to Caesar's wife, alternate remedy would be a mirage. Therefore, if an authority is predisposed or an authority has already taken a view or is bound by the view of a higher authority, really does not help you. To sum up on alternate remedy, judicial review is one of the basic features of the Constitution. So, your powers per se cannot be circumscribed by statute, but if the statute has a right and remedy, court has to respect the statute, which is why you have the principle of alternate remedy. Court will not entertain a writ petition if there is an alternate remedy. There are exceptions which I described to alternate remedy. Second, so in 226 we came to what right can I enforce? Fundamental right, any other purpose. But within any other purpose also, alternate remedy is when the court will not enforce. Therefore, even if I have a right, if I know that the remedy is not efficacious, court will not entertain, no point me filing a 226. So, I will have to know. Nature of writs. You have already seen the nature of writs. Court will exercise powers within the territories within which it can exercise jurisdiction, territorial jurisdiction of a high court. So, how did it really start off? So, initially the law was that the authority had to be situated within my jurisdiction for me to issue a writ against them. Therefore, Madras High Court, a petition was filed against the Election Commission. High Court held Election Commission is situated in Delhi. I don't have a power to issue a writ to them. Power is to be exercised throughout the territories in relation to which it exercises jurisdiction. Person or authority to whom I issue a writ should be situated within my jurisdiction. That was the law way back in 1953. Then they amended the law, which is what we today read as 226(2) of the Constitution. It was first 226 subclause 1 capital A, which became 226(2). Today, if we see the law as it is, power conferred by clause 1 to issue directions, orders or writ to any government authority or person may also be exercised by High Court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power. Therefore, it is today not where the authority is situate. You look at where the cause of action arises, which is why today in Madras, I can say Union of India as a respondent. Because if my cause of action arises within the territorial jurisdiction of the Madras High Court, I can file a writ, notwithstanding that the seat of such government authority, residence of such person is not within the territories. Understanding the practical difficulties, they said that if the cause of action arises within the jurisdiction of the High Court, you can file a writ petition. Court can issue a writ against the authorities, even if the authorities are physically situate outside the High Court. So, that amendment in the Constitution was necessitated as a result of the Saka Venkat Rao case. That was the earlier position. Cause of action has been interpreted in two cases, ONGC, many cases, but the most important being ONGC and Kusum Ingots. Now, when we talk about territorial jurisdiction, it is really coterminous with the limits of the state. A writ can be issued against only a public authority. So, a writ will not lie against a private person. It will lie against a private person only when we are dealing with the writ of habeas corpus, not very relevant to tax matters. Such authority is physically present or located within the territorial jurisdiction, yes, or cause of action arises after 226, sorry, it should be 226 1A, which later became 226 subclause 2. Now, very often people say legislation is passed, legislation applies across India, I can file a writ petition here, because that is what you really refer to as forum shopping. Let us say today I have business operations, I make imports into Madras. But for some reason, I feel that Karnataka or Delhi is a better jurisdiction. I don't have any import business in Karnataka or Delhi. Can I say a legislation is passed? I have a registered office over there. I will file a writ petition in Delhi. Supreme Court in Kusum Ingot said that you will have to read 226 holistically. Mere passing of a legislation which has all India application doesn't give you a right. There should be a cause of action which arises distinct from that legislation. Therefore, this arose in another case before the Madras High Court, which went to the Supreme Court, where Adani had imports in Madras. They had a registered office in Gujarat. They said the effect of an action in relation to the imports is being felt by me where I have my registered office. Court said no. Your imports are happening in Madras. That's the most proximate cause. The issue is in relation to your imports. Therefore, the cause of action is Madras. Therefore, when you look at cause of action, two things. From ABC versus ABC laminate, CPC, cause of action is a bundle of facts which gives right to your right to sue. That's also what you will have to apply. What is that bundle of facts? Then you will have to apply a second test. What is the most proximate fact or the most important fact, and then look at the territorial jurisdiction of the respective court. State of Goa is a summit online traders. Petitioner sold Sikkim organized lottery across multiple states. Goa issued notifications for taxing lotteries. Petitioner challenged it saying, I am based out of Sikkim, this is my registered office, I will challenge it there. Even though it was in relation to a notification issued qua the Goa business. Court said no. It's something related exclusively to Goa. You can't file a challenge because you are based out of Sikkim, you will have to necessarily do so in Goa. 226(3), which I normally say is a provision which is really not looked into, where any party against whom an interim order without, whether by way of injunction or stay or in any other manners made or in any proceedings without furnishing to such party or giving an opportunity of heard, gets an order. Now, let me just explain to you how it works in court. Normally, different courts follow different practices. In the Madras High Court, I don't need to formally serve a copy on the other side before I file my petition. Other courts have something called an advance notice where I have to serve the other side when I file a writ petition. We follow the traditional system that where court will decide whether notice has to be issued or not, whether the matter merits consideration. If the matter merits consideration, court issues notice. Therefore, in my first hearing, the other party, practically how it works, I keep 4 copies. 1 copy will go to the government. But have I given notice to the other side, I have filed a writ petition? Answer is no. Court has to give notice. Therefore, even if the other side does not come on the first date of hearing, I can get an interim order. In some courts like Bombay and Delhi, I will have to give advance notice, show that I have served the other side, only then the writ will come up for listing. So, in Madras this is relevant. When I get an interim order, 226 subclause 3, which is not a provision which is much used, says, makes an application to the High Court for the vacation of such order, furnishes a copy of such application to the party in whose favour such order has been made or the counsel of such party. High Court shall dispose of the application within a period of 2 weeks from the date on which it is received or from the date on which the copy of application is furnished, which so is later. The last portion, if the application is not disposed, the interim order shall an expiry of that period, or as the case may be, expiry of the next day, stand vacated. So, what it is, you get an interim order. Other side files a vacate interim order. Has to be heard and disposed of within 2 weeks. If it is not heard and disposed of within 2 weeks, your interim order goes. This is what 226(3) says. Not many people really look into or use this provision. Some courts have taken a view saying construe it strictly. If the other side files a vacate stay, 14 working days, nothing happens, over. Your interim order goes. Madras has taken a more nuanced view to say that if it's filed and the court cannot take it up, then you can't be blamed for the court not taking it up. Now, if you really see this order came out in 2014, but if you now try to correlate it with the order of the Supreme Court in Pepsi Food, where they said the 365 days stay getting vacated, you can't be blamed if the court cannot take up the matter. Now, that position really flows from what Madras has said. The principle is that actus curiae neminem gravebit, saying no one shall be prejudiced by an act of court. Therefore, if the court is not able to take it up, you will really have to do it. But my personal view is that if there is a constitutional provision that has to be given credence, you can't say that practical difficulties. Therefore, really if the courts start interpreting 226(3) as it ought to be, then if you get an interim order, you are safe only for 14 days. You will have to prepare for the vacate stay if they file one, and you really will have to ensure that your stay is continued. Or we will then have to move to a system where courts give notice and then really grant stay. Therefore, there is no short period for your stay period per se. 226(4) shall not be in derogation of the power conferred under Supreme Court 32(2). Okay. So, what I will do is, if any of you have any questions, I will just with the permission of the organizers, because we are already at 11:30, take 5-10 minutes, ma'am, is that okay? Can I take 5-10 minutes? I will quickly wrap through. Necessary party and proper party. Now, who do I make parties to writ petition? Necessary party is a party without whom an order cannot be passed at all. Proper party, order can be made in his absence, but in the absence of such party, maybe a complete and final decision will not be made. If I don't make someone a necessary party, they can come and say necessary party not be made, my writ can be dismissed. Therefore, when I am drafting a writ, so and so versus so and so, so and so, I will have to see, is such person a necessary party? Is such person a proper party? If he is only a proper party, then do I really need to say I am making him only as a proper party? The law on this is Udit Narayan, very important, because I myself have taken a lot of these things when I am the respondent, saying necessary party has not been made a party, that it should be dismissed. Delay latches. Now, what I will do is, I will just deal with two issues given the time mandate. Now, why did I place so much emphasis on cause of action, alternate remedy, and a few other concepts? The Madras High Court has now come out with the Madras High Court Writ Rules 2021. Okay. This is basically what it says. Rule 7 is very important. An affidavit in support of a writ petition will contain the following statement. Statement that the petitioner does not have any other alternate or equally efficacious remedy except to file the writ petition. As a matter of course, we make the statement, but it's a statement on affidavit, and I really need to understand the law of alternate remedy, not only to advise, but also for the sanctity of the statement. Statement that the petitioner has not filed any other legal proceeding on the same cause of action for the same relief. On one cause of action, I can only file for one petition. I can't file an appeal, and I can't come before the writ court also. I will have to approach the court with clean hands. Now, all that ties into this. Statement disclosing detail of legal proceedings of any relating to the same subject matter, either pending or disposed. Approach court with clean hands. So, if I understand the principles very well, then I will know why I am making these statements in the writ petition. Statement whether or not the petitioner has received caveat or not. The rules relating to caveat have still not been made fully applicable. Therefore, I still go in for ex parte, though it should probably come in force in some time. Filing a writ petition beyond statutory limitation. Before Mr. Ravi asked that question, I thought I will really deal with it. Today, when you go to court, I am sure all of you have heard, okay, you didn't attend hearing, you missed the bus, 25%, 50%, come back. Now, what am I really doing? What is the law on the subject? Sir, I can. So, I am sure Mr. Ravi, I would like to hear sir's views. I will express my personal views also on this subject. See, there are two things we are really looking at. The statute has a time limit, but the statute per se is framed under the Constitution. The Constitution has no time limit for filing of a writ petition. Therefore, when you are looking at a constitutional remedy, you are looking at the constitutional provisions. But the Constitution also, though not bound, a remedy under the Constitution, though not bound by the statutory prescriptions, has to respect the statute. Your entire theory of alternate remedy is between that. So, which is why Glaxo said, even though the High Court has very wide powers, it should not be entertained as a matter of course. If limitation for statutory appeal has expired, High Court cannot disregard the legislative scheme and entertain the writ casually. I think a very well established principle. It is just that Glaxo reiterated it. I think Jayalakshmi has also heard Mr. Ravi possibly and come in for this now. So,
It was also the context of the Madras High Court saying, yes, statutory time is over for filing a writ, but we'll give you 4 weeks time.
yes, sir. So, I will address.
Remember in the old Tamil Nadu sales tax cases, Supreme Court came out heavily on the Madras High Court.
Yes. So, this is where Glaxo said. So, strictly speaking, is there a time limit under the Constitution? Answer is no. Statute has a time limit? Yes. Should you respect it? Answer is yes. A writ may still lie on exceptional grounds: lack of jurisdiction, violation of natural justice, statutory non-compliance. Now, time and again the courts have tried to balance both rights to say that under the Constitution there is no time limit. Therefore, 226 cannot be circumscribed by statutory provisions. But at the same time, I have to respect the statutory provisions. If I have that timeline, it is one of the consideration. Madras High Court Division Bench said Glaxo does not lay down an absolute bar on writ petitions filed after expiry of appeal limitation. 226 has no statutory limitation period. High Court must apply a judicial discretion, not a rigid rule. So, this is where we really are. You also have various Supreme Court decisions saying that your power under 226 is a constitutional remedy. It is a part of the basic feature of the Constitution. So, when courts are going and saying 25%, 50%, what they are really trying to do, though the orders may not explain it in so much detail, is seeking to balance the right under the Constitution, which is not fettered by any statutory provision, at the same time also respect the statutory provision. But my personal view is that respect to the statutory provision has to be read with my exceptions to alternate remedy. Therefore, I can't just go and say I didn't participate in a hearing, I was issued a notice, but now I have come, I have to go back. Therefore, if no notice was issued and they went ahead and passed an order, is a pure violation of natural justice. My courts may still interfere. But if a notice is issued, I don't attend the hearing and I say it's an ex parte hearing, now that I have filed a 226, set me aside, I don't think such matters should be entertained. I think my personal view is when you have a statutory time limit and you decide to exercise your writ petition, you cannot have a one size fits all. Threshold should be extremely high. Your entire theory of alternate remedy is not a bar under 226. It is built on the bar that I have to respect statutory limitations. I should put this on the same par. First, figure out whether there's falls within the exceptions to alternate remedy. If a very good case is made out, then on the facts of each case, whether I entertain 226 or not, whether substantial justice will be served and there will be substantial injustice if I don't entertain my right under 226, only then I should entertain. My personal view is that it should not be done as a matter of course. I would like to hear the views of Mr. Ravi and Jayalakshmi on this. So, my personal view is therefore I should probably read the threshold at a very high level, and also if you look at how the law is developing today in 142, Supreme Court has the power to do complete justice, but if you see the way the law has evolved, they can't give an order which is contrary to statutory provisions. So, even in many of these cases, TOLA, GST and everything, everyone is saying Supreme Court cannot act contrary to statutory provisions, and the law on 142 is that they are acting in contrary to statutory provisions. So, if for 142 power also has such a high threshold, even though there is no inbuilt limitation on 226, when you are exercising the discretion, the threshold I believe should be equally high when you decide that the statutory period will really not apply, is my view on that. Now, rule 7 I already dealt with. Disputed questions of fact, you really cannot entertain a writ petition. Principles of res judicata, though they do not strictly apply to tax petitions because every assessment year is different. In respect of the same assessment year, if you are dismissed, you can't go again, you also have to make a disclosure. Delay or laches. Now, delay or laches goes back to when you can entertain. Even prior to this entire controversy about Glaxo, it was always that though there is no prescribed period, you will have to approach court at the earliest. If there is a statutory period, you will have to approach court within that statutory period. If you approach court beyond that period, you will have to explain the reason for delay or laches. And taking off from where Mr. Ravi had said, if a person had an accident, he was not able to, the proprietor is the only person. That is a ground for explaining delay or laches, and probably that will be an exceptional situation, apart from when there is natural justice violation of this thing. But in non-exceptional situations, you should not really go against the statutory mandate, because that will go against the very fine balance between your constitutional power and legislative powers. Supervisory jurisdiction, it is more an administrative jurisdiction under 227 than a writ jurisdiction. Lot of courts they file saying under 226 and 227, I ask for a writ petition. Strictly legally speaking, that is wrong. My power of writ is only under 226, my 226/27 is only a supervisory jurisdiction per se. 226 is original, 227 is a supervisory or revisional. It's a writ, it's my right or my authority over a subordinate court or a tribunal. Okay, I think I will.
Please go to your second slide. Now, can you use a decision in a writ as a precedent?
Precedent in what, sir?
Can I say that I find?
Yes.
Or is it merely persuasive?
Okay. The answer to that, I will answer it in two this thing. One is the doctrine of judicial discipline, in terms of which an order of the court is binding on all authorities below it, and the court itself has to follow that. Exception to that is if the court wants to take a different view. Let us say if a single judge has taken a view, a different single judge wants to take a different view. Law as it is evolved is he should refer it to a division bench. There is a Supreme Court decision in Central Dawoodi Bora, which is the best decision on issue, which says that judicial discipline for judicial certainty really requires that you should follow your decision. Exception to it is that all decisions are rendered on individual facts and circumstances. If it's a pure decision on law, that should be treated as a precedent. If it's a decision based on some peculiar facts, you will have to necessarily show that your facts are similar to that. If facts are distinguishable, and it's rendered in a specific factual circumstances, it will not apply as a precedent. Final orders are applicable as precedent. Interim orders, because they are on a prima facie basis, don't have precedential value, but there are decisions to say that there should be uniformity in interim orders. So, it's not a precedent, but more basis the principle of uniformity. Yes, ma'am. Yeah. So, there are two parts to that. Legally speaking, there is a constitutional power where the president can seek a reference. So, this was an exercise of the power where the president seeks a reference, which is under Article 143 of the Constitution. On an issue which is already decided by the court, whether a reference can be sought or not, ideally I would think no, it is definitely not. But if the reference was sought on various issues, one of which has been decided, then probably they should have said one has been decided, we will answer the other questions. Practically then, if let us say there are 5 questions, question 1 has been decided, but my answer to questions 2 to 5 will have me decide 1 also. I will then necessarily have to do it. One answer is that the jurisdictions are different. Therefore, the presidential reference does not automatically become law of the land in terms of Article 141, which is why what will have to possibly happen today is there is a presidential reference. They will have to now review the decision taken by the other 2 judges. Once that is reviewed, that has to be set aside in law. Today, if you see the presidential reference also, the last line, they have said this is only for the reference, it will not apply to any other facts and circumstances. Therefore, the ideal course will be for the other judge file a review before the other judge, set aside and review, it's in consonance with the presidential reference, law speaks in one voice. Otherwise, matter gets taken up by some other division bench, has to be referred to a larger bench, and probably they should follow the presidential reference. Presidential reference is by 5 judges. The earlier one was by 2 judges. But given uniformity in law and how it works, this is where we are. Ma'am, I think we will have to go for a tea break. If I need to answer your question, I can do that right now, or do you want me to do that separately, ma'am? Yeah. No, I'll just go to that, and with that we'll stop, ma'am, because the next speaker also I won't want to introduce. I've already done that a bit. Yes. Sorry, I think I've. Ma'am, the answer is when I'm talking about efficacious, I am not referring to commercial efficaciousness or mere hardship. Efficacious is more a legal concept. Today, let's say I have a right of appeal to the Commissioner Appeals, but the tribunal has decided the issue. In that case, I will not get any relief because he is bound by the tribunal order. In that case, my remedy is not a efficacious remedy because of the principle of judicial discipline, he is bound by it. Therefore, mere commercial hardship or necessity will not result in it not being an efficacious remedy. Only situation like this is, let us say, practically by the time he does not have the right, if it affects his right to grant a refund, so it has to have a legal bearing. Then I can say it's not efficacious. Mere commercial hardship or commercial efficaciousness, either for the client or the time taken for the remedy, is not efficaciousness, which is referred to over here. Yeah. Thank you so much. I think let's now hear Jatin speak on a very, very topical and important topic. Thank you. And thank you, Revati ma'am and Ravi sir.
Thank you, sir, for your thoughtful and enriching address. Your clear exposition of Article 26, 14, and 19, the scope of prerogative writs, and the distinction between certiorari and prohibition has significantly enriched the session and strengthened our understanding of the principles governing writ jurisdiction and MHC writ rules. So the real-time scenarios shared by you provided valuable insight into jurisdictional and adjudicatory facts. So once again, we thank you for your expertise and contributions. Members, we will now break for 10-minute tea break. Practice and interpretational issues has guided professionals across the country. We are privileged to have him walk us through the nuances of GSTAT proceedings today. CA Jatin Christopher is a chartered accountant, cost accountant, and law graduate qualified in 1996, specializing in indirect tax laws. He is a published author and a key resource person for ICAI in its post-qualification programs and contributes to ICAI's educational and research publications. He also supports government training initiatives for practitioners, trade bodies, and departmental officers. He has been in professional practice since 2000. He is a partner at JCSS, a full-service firm with a pan-India presence. Over to you, sir.
All right, welcome back, friends. When we look at tribunal procedure rules, what we are actually trying to find answers for ourselves. Thank you. What we are trying to do is to find answers for ourselves as to what is going to be the outlook once the tribunal becomes operational. But please keep in mind, some of the points that were discussed in the previous presentation are extremely important for chartered accountants. Advocates understand this. For chartered accountants, this is something that's extremely important. There is a decision of Supreme Court in CIT versus Scindia Steam Navigation, 1961 AR 1633. Supreme Court says, before you approach the High Court, you must demand justice be done. You must demand that justice be done and show that the demand was rejected by the officer. So my question is, like Karthik sir was saying, chartered accountants are making a decision whether we can carry this matter to High Court or not, and we all understand the reason why this decision is being made is on the assumption that there is a pre-deposit for statutory appeal. There is no such pre-deposit mandated for writ petition. Therefore, we should be in a good position to pursue writ remedy. But please keep in mind, Madras High Court has shown over the last 3 years that going to High Court is worse than going to appeal. You have set the trend for everybody. Madras High Court has only said 25%, we will also impose 25%. Yerkane we have paid 10%, now another 25%. And if you argue too much, it becomes 50% also. 100% also. Excellent. So therefore, friends, let me ask you this question. In all the proceedings where we are considering to go to High Court, have we demanded justice? And can we show that that demand was turned down so that there is cause of action to carry the matter to High Court? Ravi sir made a very important observation, whether decisions by High Court in writ routes is a binding precedent. Again here Madras High Court only, very famous. It says, if you have not been able to claim transition credit by filing Tran 1 declaration, you claim in 3B. Sir, ungala patti da. If you can't file transition declaration, for whatever reason, sir sonna madri laziness irukkalam. If you have not filed transition declaration to claim transition credit, no problem, you claim it through 3B. You didn't claim through 3B, claim in 9. oh, 9 you cannot claim it. Okay, sorry. Then you claim in 3B. This month 3B you got. Next month you claim 16 for. You don't worry about it. You claim. Please bear in mind, to answer, I'll offer my perspective on the binding nature of outcome in a writ petition. If the court interprets the law, if the court provides an interpretation of the law, then that is precedent. Doesn't matter whether it is a revision petition or a writ petition. But if the court molds relief, it molds relief to the petitioner only. It is not a precedent. After 3 years also they have admitted writ petition, first appeal, so let's go to the DC appeals and file appeal after 3 years. Friends, let me ask you this question. Recording pettirukku madam? Paathu pesano. Okay. Consider one aspect. I have filed appeal in the 5th month. 107(4) says the time for condonation is only 1 month. I have filed the appeal in the 5th month. And when I am already in the 5th month, there we are screaming fundamental rights. Vande Mataram, all that we are doing there. Tevellada emotion idella. So therefore, please consider column number 7 APL1. What is column number 7 APL1? As chartered accountants, in the column, forum, idu vecha namukku trupti. We like these things. The date of order, column 3. Date of communication of the order, column 7. What does 107(1) say? 107(1) says, you have to file appeal within 3 months from the date of communication of the order. What is the communication of the order? What you say is the communication of the order. How can you say it is received by you in the 4th month from passing? How will 1 plus 1, how much is 1 plus 1? 7. எப்படிப்பா சார் நீங்கள் கூட தப்பா போடுங்க உங்களுக்கு 7 வரும். You understand? First you have to take a stand. When did the order get communicated to you? The order may have been passed by the officer. We've seen contract law. When is the offer, when is the acceptance complete as far as the offerer is concerned? When is the acceptance complete as far as the So therefore, please bear in mind, you have to identify what is the stand you have taken in APL1, and very sadly, we have copied column 3 with column 5. Why? Because it is auto-populated. It is editable field, we don't even realize it. Now the question is, how can you say you did not receive the order? See, the purpose of serving an order is not to finish a task. The purpose of serving an order is to inform the other party to either discharge the demand or to avail the further remedies available in law. Fairness is not just ending with adjudication. Fairness extends even to communication of what is adjudicated. Now, the revenue must accept the capabilities of the taxpayer to receive online communication. There are two assessees. See, equality is not equal treatment for everybody. Equality is when equals have to be treated equally. So it is equality if unequals are treated differently. If two persons are not equal, you can give them different treatment, that is equality. There are two taxpayers. One is an IT company. You have served the notice order online. It is very reasonable to expect that that IT company will regularly access the GST portal. There is one taxpayer in Bangalore. He supplies sweepers to local municipality. To the corporation, he supplies sweepers. Now, if you expect this manpower supply agency for him to access GST portal regularly. He gives his mobile phone to somebody to send WhatsApp message on his behalf. He will give his mobile phone to somebody, gives them instruction what message to send in WhatsApp, where he uses the mobile phone completely on his own without any help is only to watch those news channels. Yes, sir? So therefore, please be very careful. What is the position being taken as far as fairness is concerned? Here from Madras High Court, we have a nice decision of Axiom Gen Next, India Private Limited, where they say, among other things, nowadays lengthy judgments has become trendy. Surakama idu solla mudiyadu. Index, chapter 1, chapter 2, chapter 3, chapter 4. In the decision they say, once the registration has been cancelled, suo moto or otherwise, to expect assessees whose registration is cancelled to continue to visit the portal is unreasonable. That is enough. Which means always access the portal is not the uniform law everywhere. If the circumstances are different, the treatment can be different. But everything starts by saying, what have you admitted in APL 1 as the date of communication of the order? If you say that the order was communicated to you on the same date when the order was passed, some mysteriously, nobody can come to you. That is the point I agree with, sir. You have to suffer the consequence. You have to suffer the consequence. But please bear in mind, a reply to a notice, an appeal memo, a ground that you take, the delay that you admit, the delay that you don't admit, it is a stand you are taking in the matter. Reply to a notice is not a justification of what you have done. Normally I say this among chartered accountants, this is common. We like to write long answers. You know, right from intermediate this is going on, finally it got perfected, now we are always on anything long. Leave letter 7 pages. Oh, now that also is another variation. Leave letter 7 pages. From there we will start. See, that is, you have to bring your boss to such a condition that as soon as you 7 pages, leave application. You understand? Please be very careful. Reply is not a justification of what you have done. Reply is a stand you are taking in the matter. And the stand you are taking in the matter is accept and discharge the liability, dispute and litigate the liability. That's all is the stand. Why? To reject the allegation made by the department, you don't need to have reasons. It's a stand. I reject it. Now what to do? Now you have to decide what you want to do. It is a case you are trying to make out. Why? Because this is a self-assessment tax. Every registered person shall self-assess the tax payable under this Act and discharge the tax through the returns filed under Section 39. That's all. If you think you are not satisfied with me, you tell me what is the problem with my return. That is not enough. Something is not matching something. See, something is not matching with something is a real business. ஒருத்தர் சொன்னாங்களே ஒரு கன்சல்டன்ட்டுக்கு போயிட்டு, சார் ஐ வாண்ட் டு ஹேவ் அ மீட்டிங் வித் யூ, வி வாண்ட் டு டேக் யுவர் கன்சல்டன்சி. என்னப்பா பண்ண போகிறீங்க? சார் ஒரு ஃபேக்ட்ரி ஆரம்பிக்கலான்னு இருக்கோம் சார், வி ஆர் பிளானிங் டு ஸ்டார்ட் அ ஃபேக்ட்ரி. சரி, அந்த ஃபேக்ட்ரியில் என்ன பண்ண போகிறீங்க? சார் ஆக்சுவலி வி ஆர் பிளானிங் டு மேனுஃபேக்சர் இன்வாய்ஸஸ் சார். எதுக்கு சார் வீணா ரா மெட்டீரியல் வாங்கி மேனுஃபேக்சரிங், லேபர் ப்ராப்ளம், எட்ஸட்ரா எட்ஸட்ரா, சேல்ஸ், டெட்டர்ஸ், பில் டிஸ்கவுண்டிங், ஏகப்பட்ட கன்ஃபியூஷன். கடைசியில் இது தானே சார் நிற்கும். ஸோ ஸ்ட்ரைட் அவே லெட்ஸ் கோ ஃபார் த இன்வாய்ஸிங் சார். போட வெளியே வச்சுட்டாங்க. ஸோ ப்ளீஸ் பி வெரி கேர்ஃபுல். வென் திங்ஸ் ஆர் மேட்சிங், இட் இஸ் சச் ஃபெலோஸ் ரிட்டர்ன்ஸ் தட் ஆர் மேட்சிங். பிகாஸ் இங்கே தான் GSTR 1, இங்கே தான் 2A, 2B, 3B எல்லாம் இங்கே தான். A real business, things will not match. When things don't match, it will have an explanation. That explanation needs an inquiry. Therefore, please be very careful. Notice is issued under chapter 15, whichever section, 73, 74, 74A, 76. A notice is issued under chapter 15. A notice cannot come into existence in vacuum. This is not matching, so notice. A notice cannot come into existence in vacuum. It means a proceeding should lead to a finding that justifies issuing a notice. Something should be done. This is where I am very sorry to say Armor Security missed the bus completely. To dismiss a writ petition, why 99 pages? It was a dismissal of writ petition by Supreme Court. If you're going to dismiss it, that's all. Short and sweet, dismissed. Why all this discussion? And in WhatsApp University, any judgment is very good. Shanti Kiran also we will celebrate, Armor Security also we will celebrate. Heading we will read, last page we will read. That's what Mr. Karthik was laboring to explain what were all the pages in between. So please be very careful. Does your show cause notice arise out of vacuum? We should know. If it cannot arise out of vacuum, how can it come into existence? It can come into existence after proceedings under chapter 12. That is sections 59 to 64. Or chapter 13, 65, 66. Or chapter 14, 67 to 72. I'll draw your attention to two sections, subsections you will understand. Section 61.3. 61, ASMT 10, the notice, 61. 61.3, if the reply is not to the satisfaction of the officer, if the reply, that means there is an ASMT 10 and the reply is not to the satisfaction of the officer or no reply is filed, then the proper officer may proceed to initiate 65, 66, 66, 67, 73, 74, 74A. The proper officer himself cannot proceed directly. It all depends on the nature of the issue. If the discrepancy is in the return, he can himself issue a show cause notice. He need not send it for audit. For example, 2A not matching 3B. Because of rule 88D, 2A not matching 3B or 2B not matching 3B, he can issue show cause notice. You got it? Which means, what is it that the proper officer can do in 61? He can only scrutinize the returns. A proper officer under 61 cannot raise a question saying, your classification is not correct. Proper officer sitting in 61, he cannot say your classification is not correct because that is a adjudication fact. He has to apply his mind. He needs information. He needs to see my factory. He needs to see my raw material. He needs to see how I have come to the classification. He needs to now bring evidence to impeach my classification. Therefore, in 61, he does not have jurisdiction to touch classification. That can be done in 65 or even 67 to a limited extent. But he is not the proper officer under 65. He is an officer, but not proper. He is not the proper officer qua issue. Qua the issue, he is not the proper officer because the issue involves a subject matter beyond his jurisdiction under 61. That is jurisdictional fact. So therefore, there is territorial jurisdiction, there is subject matter jurisdiction, there is administrative jurisdiction. Territorial jurisdiction, Mylapore, territorial jurisdiction. Subject matter jurisdiction, I am appointed as DGSTO, so therefore I can only do chapter 12 proceedings. I can't do chapter 13 proceedings. I am audit commissioner at Chennai 1. I can do 65, 66. I can't do 67. I am DGGI. I can do investigation for evasion of tax. But DGGI is sitting doing 2A, 3B, 3B, 4B, 4B, 5B, 5B. This is what it is. Nobody knows what to do. When you don't know what to do, when you don't know how to answer the question, you write the question 3 times neatly and submit answer paper. So please be very careful. How does your show cause notice come into existence? What is the reply? What's the stand in the reply? The other aspect that we have to consider is rules of evidence, though not with the same rigor, are applicable to taxation also. 94 ITR 616. So please be very careful. Evidence law is not inapplicable to GST. But then what happens, as chartered accountants, we practice income tax and GST. So therefore, we are not able to compartmentalize who has the burden to prove. In income tax, what is conducted is assessment. I have filed the return. If he does not get selected, it is deemed to be assessed. If he gets selected, he will ask questions, I have to satisfy him. Proof of innocence. But in GST, it is not assessment, it is adjudication, because they issue a show cause notice. When they issue a show cause notice, what is a show cause notice? Show cause notice is a proposal. A proposal to levy tax different from what you have self-assessed. It's a proposal, so therefore, burden of proof is on the one who is putting this proposal forward, but we are taking that assignment on subcontract basis. We are so used to it. Reconciliation. 2A not matching 3B. 2A not matching 3B? Naladane. It's good. If it is matching, only problem. No, but we will do reconciliation. The reconciliation only irukke. Reconciliation panni palagi poiduchu. We are so good at reconciliation, we can reconcile anything with anything. Sela samaya debtor with creditor also will reconcile. The beauty is it will tally also. That is easy. Please bear in mind, allegation left undisputed become fact. Because proof is now no longer required. You also agree. You also agree. I have made one allegation. You have not contested it. You have given some explanation. In the explanation resides admission that this allegation is with merit. Now, whether your explanation is satisfactory or my allegation has to sustain, that is the only matter, and there is sufficient motivation to reject your answer. You think when you give an answer, the other side is interested to listen to your answer, appreciate the beauty of your answer, and drop the demand. This sentiment of locating defects, discrepancies, failures in the reply, who can understand better than auditors? We understand the sentiment better. Everything is okay. Still we want to send ML. So therefore, please bear in mind, have we taken over the responsibility to prove revenues case? Brings us back to the question, when we are filing appeal, are we filing appeal to prejudice our case, or are we filing appeal to strengthen our case, whether we go to Karthik sir and he helps us take the matter to court, or are we going to statutory appeal itself? Some cases are better not to go to court. He rightly made this observation. I respect that. Some cases are best not carried to court because even by obiter, if the court makes a passing remark on the facts in your case, you are finished. I will invite you to please read one judgment of Allahabad High Court. 273 crores penalty imposed by the officer in respect of 3 distinct persons of the same person. 3 distinct persons of the same person, 273 crores penalty imposed for fictitious credits being passed on. In para 26 and para 38, the court summarizes the jurisprudence of the last 70 years. Burden of proof, all the points that Karthik sir mentioned have been summarized there. So much so that they have concluded to say that this 273 crores is to be confirmed. You understand? So when you look at what's going on, please be very careful. What is the consequence of what you are saying has to be very carefully. It's not about the answer that you are providing. How many have been married for more than 20 years? Kindly raise your hand. Don't mind, kindly raise your hand. See, this is where wisdom resides. The others are all, madam, you are okay. The others don't know. See, when a question is put, This is not about gents or ladies, it's about for everybody, because wisdom will come to in 20 years. When a question is put, knowledge tells you what you should answer, but wisdom tells you whether you should answer. Because that question and answer is not the conclusion of the conversation. That question is that is that box that everyone keeps referring to as Pandora's box. box. So please be very careful. What is the consequence of the answer you are providing? When the other side is sufficiently motivated to turn down your answers. In your answers, is there admission of wrongdoing? In the course of providing an explanation, in the course of justifying and proving your innocence, many times taxpayers are blinded by their innocence. They plead for lenience. When you plead for lenience, the precondition for lenience is no contest on offense. There is no contest for offense. In Bangalore, there is one place where there is a bar. And coming from that road, there is only one way to go out of that place, and it's a one-way road. There are no other branches anywhere. And invariably there is a blind spot, and there is a constable always standing there. I don't know, such places only they give bar license, or wherever they give bar license, they create one-ways. I don't know how it is. So therefore, this one constable stopped this man, said, stop. You understand? He says, enna kudichirikya? What should be the answer? What is the answer is not important. What should be the answer? Madam seems to be enjoying. What is the answer? He's going out, 11 o'clock. 11 o'clock. See, he has to take a stand. He has only two options. Pay fine or not pay fine. That's all. No one's interested in your answer. Whatever you say will take you down one of those two paths. Even the Buddhisali. Rumba idartham. He says, Ama ana konjanda. See, the dispute is not quantity. The question has binary answer, yes or no. In order to contest, he is forced to say no. குடிக்கல பின்ன ஏன் ஸ்ட்ரெயிட்டாக நடக்க முடியல நீங்கள் லைன் சரியாக போடுங்க சார் நான் நடந்து காட்டுறேன் யூ அண்டர்ஸ்டாண்ட் வாட்ஸ் த இஷ்யூ தட் ஹேஸ் டு ஸோ ப்ளீஸ் கீப் இன் மைண்ட் வாட் இஸ் யுவர் ஸ்டாண்ட் இன் த மேட்டர் he is not going to be impressed with your answer. He is going to confirm the demand. If you are prepared that he will confirm the demand, you will be prepared that this is going to go into appeal. But we are so confident. We want to parade our innocence, plead lenience. Then we say, see, others are doing. This is not jurisprudence. What the law mandates you to do, have you done it or have you not done it? Yesterday there was a matter, very small issue, very significant issue. Assessee, the notice says, you are running a restaurant. As you know, restaurant has a tariff of 5% without credit. And the assessee, the notice goes on to say, from your returns it appears you have claimed 40,000 rupees credit. You have claimed 40,000 rupees credit. Since you have claimed credit, pay 18% tax. 1 crore 17 lakhs is the total demand. So we went to appear for the adjudication. So he said, you are admitting that I am running a restaurant. What are you running? அதெல்லாம் சொல்றதுக்கு இல்லை. You are saying that I am running a restaurant. Restaurant is always 5%, no credit. It is GTA, which is 5% without credit or 12% and now 18% with, that option is there for GTA, not for restaurant. Either you deny 40,000 rupees credit or you let it be. But sitting in 61, you cannot say pay 18%. What is the 18% on? What is the HSN code? There is no 18% for food and beverage. So therefore, where is the question of 18%? Now he has a dilemma. He has to drop the demand of 1 crore 17 lakhs. he cannot confirm the demand for 40,000 rupees also. Now, if he confirms the demand, that 40,000 rupees revenue will be lost forever, and eventually this demand also will fail. If he drops the demand, in this order, can he confirm the 40,000 rupees? No, that amounts to amendment of show cause notice. So he lost that, he lost this also. The reply is not what you are doing. The reply is what is the stand you are taking in the matter. Somebody said you are a works contractor. Somebody said you are a works contractor, so therefore you are classified under 9954, you have to pay some 18% tax. So reply was, how did you come to conclusion that I am a works contractor? Because in 219, works contractor is a works contractor only if the result of the is an immovable property. And again, I am reminded of this 1974 AR, Northern SIRC Fiber of Madras High Court, which says that for the beneficial enjoyment of immovable property, if you put up a structure, that is immovable property. Now we have Bharti Airtel, which says that mobile phone tower itself is movable property. Mobile phone tower itself is movable property, so most of the other things that have been disputed that it is movable or removable have got settled. Now to say that I am a works contractor, there has to be a finding. No, your letterhead says engineers and contractors. Sir, next month I will print letterhead share brokers. I will cancel my registration. Is it possible? No. No, at the time of registration, you have said 9954 works contract. That time, that was the plan, sir. See, when you joined high school, what was the plan? Not to become lawyer, not to become CA. IAS da, medical da, minimum IIT da. And the 2 வருஷத்துல so therefore many things developed during those 2 years. We came into this direction. So therefore please bear in mind, none of those criteria. Last point he said is TDS has been deducted under 194C. Sir, tell me, everyone practices income tax also. Why does anybody deduct TDS under 194C? Answer fast vanda tappa vandrom, konjam porumai irukattum. Why does anyone deduct TDS under 194C? To avoid TDS under 194J. அவ்வளோதான். டிடக்டே பண்ணலன்னா அந்த 40A 1BZ என்னமோ இருக்காமே, கரெக்டா? அதில் 30% போயிடுமாமே. ஸோ வி வில் டிஸ்கஸ், சார் ஆல் சப்ளையர்ஸ் வி வில் சே 10% TDS. ரொம்ப கரெக்டாக பண்ணாங்கன்னா ஒரு 5%. அதுவும் முடியல 2. ப்ளீஸ்ப்பா 1% நான் டிடக்ட் பண்ணி தொலைக்கிறேன். ஸோ தேர்ஃபார் ப்ளீஸ் பெர் is 194C at all any evidence? Very beautiful judgment recently of Larsen and Bosch and Lomb versus National Faceless Authority, Income Tax. National Supreme Court decision to say, we have all been suffering for many years. 26AS is not matching anything. Correct, no? It was not matching excise returns, not matching service returns, not matching GST returns, not matching your books of accounts also. Correct, sir? I was so happy when I saw this judgment. Income tax practitioners also are having same problem. This case was ICE gate data, bill of entry in customs, ICE gate data not matching with ITR. Appa nimmadi. If only we are suffering, you feel bad. If they are also suffering, okay. Just because these two data are matching does not mean everything is correct. Just because it is not matching does not mean everything is wrong. So please be very careful. How have you set the stage for tribunal? When you come to tribunal, it is second stage of appeal. Let me ask, in Tamil Nadu, has 2025 Finance Act amendments been passed and state GST law amended or not amended? How many know the answer? How many want to guess the answer? Kuntru. You know the answer? Passed, not passed? Tamil Nadu has. The reason why this is very important is, I'll tell you. Appellant has we filed an appeal for a 130 matter, confiscation matter. And we filed appeal, we had paid, at that time this amendment was not passed, so we didn't make any pre-deposit. That appeal got dismissed. We have to go to tribunal. We have filed a declaration under Circular 224 saying that we wish to go to appeal. Don't take any precipitative action. Officer sent a letter saying that please make the pre-deposit. Please make the pre-deposit. About 4 crores was the confiscate, the redemption fine that was imposed, along with some 122 penalty of some 5 lakhs. So we said that amendment has not been passed. So therefore, we will not make any pre-deposit because there is no tax in dispute. In Karnataka, that amendment has been passed. 2024 amendments were notified by an ordinance, and 2025 amendments were notified from 1st of October 25. He wrote back saying that amendment is passed in Karnataka also. So we paid 10% pre-deposit on that 5 lakhs and nothing on this 4 crore because that second proviso to 1076 or 112.8 says 20% of the penalty. Redemption fine is not penalty. So therefore, on this we are not going to pay. Now he has kept quiet. Otherwise, his anticipation was that he will get 80 lakh rupees pre-deposit on the fine also. Friends, please bear in mind, this is completely revenue. Justice we will see later. First, revenue. First, the objective is revenue. My question to you is, can you see that that is the objective in every engagement we have with the department? The purpose of engagement with the department under 12, 13 or 14 is not to find out how you have done your self-assessment. I was sitting at office and wondering how you have done the classification, and they send you summons. You give answers. Wow, excellent. I appreciate it. Thank you. That is not the purpose. That is not the purpose. இவன் ரொம்ப நல்லவன் கிடைச்சிருக்கா இவனை வச்சு we have to set an example out of this fellow. You understand? So therefore, appeal is inevitable. We will find ourselves going to tribunal. Therefore, we will need to be very mindful of what 112 talks about. So therefore, you have to file appeal in APL 5. That APL 5 is, I'm very sorry to say, the most horribly drafted form. Ask us, we know how forms are designed. We design forms, all the forms, checklist is something that we grew up hating. So therefore, please bear in mind, as far as the nature of dispute, there is a drop down. There is a drop down as far as the nature of dispute. 38 options are there. 38 options. I saw one gentleman come out of the ladies' washroom. In the morning, I saw one gentleman come out of the இருக்கிற ரெண்டு சாய்ஸ்ல சில சமயம் இருக்கிற அர்ஜென்சியில் ஏதோ ஒன்று இப்படியெல்லாம் நடக்குது. 38 ஆப்ஷன்ஸ் இஃப் யூ கிவ், I am very confident we will make mistake. எந்த விதமான சந்தேகமே கிடையாது. இருக்கிற ரெண்டு ஆப்ஷன் சின்னதுலேருந்து தெரியும். There is one photo of a boy with a shirt tucked inside. There is another photo of a boy with his shirt tucked outside. Correct தானே? Sir? Urgency, correct. When you are filing APL 5, APL 5 is a form of appeal. Who is going to upload the form? Not the partner in your office. The partner in the office has decided everything, seen the draft, corrected. But what is getting uploaded, who knows? Those days when 9 had to be certified by chartered accountants, we are very grateful that is gone. 9(9)C had to be certified. This partner verified everything, 3 drafts, discussions, over 15 days to finalize one 9(9)C. This final draft, he gave it to the boy and his team member. He said, Parappa, idha vechi nee file padu. No problem, sir. Auto-populated file has been uploaded. Ayyo, sir. See, what is the partner? Not in control. Partner is basically chief OTP officer. No, you please see what you do in office. Don't laugh. Romba serious ana matter. As a partner with the biggest cabin in your office, what are you doing? Everybody is coming to you for OTP. Have you done vouching? Don't know. Ledger review? No. Income tax? Don't know. GST? Don't know. 1? Don't know. 3B? Don't know. 9? Nothing you know. Correct, no? You are only giving OTP to everybody. Any work in your office nobody wants to do? Adhik dane na irke Balakumara. That is what I am here for. Correct? Sweeper didn't come today. I will take care of it. Landlord wants to increase rent. Of course, I am the main person. In intermediate, I studied how to negotiate. All the useless work comes to me. 9 got uploaded. APL 5, when it gets uploaded, out of the 38 options, which is the correct option? Who knows? So therefore, we need to be very careful about tribunal procedure rules. APL 5 is most respectfully useless. Tribunal procedure rules, I am very, very sorry to say, it is more than that. Why we need 124 rules? Full GST only we have how many, sir? 164. For tribunal procedure, why 124? There are many things that are copy-paste that has no rule. Court diary chapter, maintenance of register chapter, why we need all that? அவங்க வேலை அவங்க பண்ணி போட்டுமே. நான் என்னெல்லாம் பாடுபட யாராவது வந்து சொல்லிகிட்டே இருக்கேன்னா சைலண்ட்டாக சஃபர் பண்ணுறது. ஐ எம் சஃபரிங் சைலண்ட்லி இன் தி ஆஃபீஸ். என்ன சார் அப்படி தானே? அப்படி தான். ஸோ தேர் ஃபார் ப்ளீஸ் பி வெரி கேர்ஃபுல். தீஸ் ரூல்ஸ் will undergo amendment when we don't know. Tribunal has to be formed. Karthik sir is filing writ petition everywhere. Sir is also contributing in his own way for courts to pull up the government. When you are forming tribunal, we'll form it up. எப்படியோ படிச்சு நல்ல கரெக்டாக படிச்சு எக்ஸாம் எழுதணும். அந்த ஹால் டிக்கெட் வந்தப்போ தான் புக்கே தேட ஆரம்பித்தோம். கரெக்ட்? 1, 2, 3 supposed to be the returns. வந்ததா? இல்லை. எல்லாம் A, B, C, D, Z இருக்கும் ஃபாரம்ஸ். You understand? So therefore, tribunal also will get started. போக போக அப்படியே பழகிடும். இம்ப்ரூவ் ஆகாது, பழகிடும். So therefore, appeal will be filed. When you are filing appeal, please be very careful. Approach APL 5 very strategically. What is important? Distinct person important. Which distinct person? எல்லாம் நாங்கள் group of companies. இதெல்லாம் கிடையாது. Which is the distinct person has to be very clear. What is the date of communication of the order? Very important. For example, if there is a dispute involving classification, the form says, what is the classification according to you? What is the classification according to you? சொல்லுங்க பார்க்கலாம். No. We have disputed the classification proposed by the department. We have nothing further to say in the matter. What remains to be examined is if the order in appeal or revisionary order is sustainable in law or not. That's all. So please be very careful what you are saying. Weigh your words when you use this. Statement of facts, grounds of appeal. We are again used to writing long answers. Case law in grounds. Case law quote பண்ணாமல் இருந்தால் தூக்கமே வராது. I remember I was teaching final, students used to come and ask, last class, finish the batch, now they have to go for next 2-3 weeks of study and then exam dates will start. See, a final student will ask one doubt. Every batch, one doubt. How important is case law? For exam, how important is case law? How important is cause title? How important is citation? There are valuers who come and say, tax papers have answers containing, in a celebrated decision of the Honorable High Court, the learned judge said as follows. அவங்களே ஏதோ எழுதி in income tax rules. As far as what is grounds of appeal, it is the ground on which you are aggrieved. It is not argument. I'll give an example. This happened very recently in SESTAT. True, sir. No, GSTAT procedure rules also provides that it should not be argumentative, but namakku puriyaname. We have taken extra answer paper.
Another example, a writ petition I talked of years back was filed in the Madras High Court where they said, I respectfully submit. They said, sorry, there is no writ petition, it's true. He said, an affidavit will only be a statement of fact. You have to comply with that.
True. See, the strictness with which we have to draft the grounds is this point that sir is making, which is very, very valid. So please be very careful. Grounds. This example I was bringing your attention to was an amendment application, a miscellaneous application was filed in SESTAT praying for tribunal to allow appellant to amend the grounds. He wanted to make an amendment, so he's moved an application. And it came up for miscellaneous matters listing, it has come up, he wants to argue, and when he's arguing, says, I want to amend this. So the bench asked, what have you said in your appeal? what is it that you want to amend there? Do you want to withdraw a few grounds and substitute it, or what do you? He said, I have cited a particular judgment in the ground. That judgment has now been further refined in yet another judgment. So now I want to add a ground to include this subsequent decision also. Bangalore SESTAT has a pendency of 10 years. 2016 matters are being taken up on priority. 2019 or later appeals, you can ask for adjournment. 16 appeals, you can't ask for adjournment. If the reasons are really serious, then 1 week adjournment is given. By the time these matters reach tribunal, how many amendments is going to make? So what should the grounds be? The ground is not that the impugned order is contrary to this decision. The ground should only be that this impugned order is contrary to extant judicial authorities. Whatever the authority may be at that time, it is contrary to that. So therefore, please be very careful. No case law, no arguments. It's a position. But when will I explain myself? We are so eager to give reasons for the answer. There's a time when you have to provide this. The grievance I have about the tribunal procedure rules is, Rule 18 talks about filing the appeal. Rule 21 and 27 talk about two aspects. Along with your appeal, you have to submit all the documents that you wish to rely upon during disposal. No one's made any noise about this. 1 minute. In those 3 months, actually they will come in the last minute. In those 3 months, if you manage to get the impugned order, authorization, pre-deposit, that itself is an accomplishment. Where will you go back and say OIA, APL1, OIO, SCN, reply, ADD2? When will you go back and collect all those documents? Then why does Rule 21 say enclose all the documents? Does it mean that there is no paper book procedure? If appeal is filed, after filing the appeal, file paper book with all the documents we wish to rely upon. When you go for the hearing, provide synopsis, carry a compilation. You will see in the afternoon session. Carry a compilation. Present your matter. When it may come up, we don't know. But if everything I have to provide now, will I make another paper book subsequently at the time of hearing? This is something that's very, very concerning. Rule 27, calling for records. This is not even funny. In Karnataka VAT Act, for a VAT appeal to be disposed of, 16 to 25 hearings. 16 to 25 hearings. First 3-4 hearings is to confirm that your appeal is filed within limitation, with all enclosures, pre-deposit paid. Next 3-4 hearings, if there are conditions imposed, for example, bank guarantee in case of the amount stayed, etc., another 3-4 hearings. There is a practice in VAT which seems to be in the rules, although it's not there in the Act. It says calling for records. You know what calling for records means? That tribunal will pass directions, which is why what Karthik sir was explaining about the procedure in court is very important for us to pay attention to. It's not like we file appeal, tomorrow morning it will come up and you'll get final order. You understand? So therefore, the tribunal is going to give directions that all the authorities before, it will be show cause notice, first appeal, show cause notice, adjudication, first appeal before we go to tribunal. Some cases it will be show cause notice, adjudication, first appeal, revisionary proceedings, then we will go to tribunal. So 3 or 4 stages documents have to come. Friends, I'm telling you, it will take 5 years before documents come. If all documents are on the common portal, what is the problem for API integration for all the documents to flow directly to the tribunal? Or appellant will file the documents. If respondent has a grievance that some documents are missing or incorrect, he can raise objections. These rules need to be examined very carefully. There's another very interesting rule I want to bring your attention to. Sir is here. I'll lean on you for some guidance, sir. Rule 44 says 60 days for you to make an application. It's called an impleading application. You make an impleading application saying that LRs will be implead. What does it mean? Proprietor got show cause notice, filed appeal. During the course of the pendency in tribunal, proprietor mar gaya. Now there is a rule that says the daughter or the son can join this matter. 1 minute. How can the LR continue the appeal? Please consider 159(2)(b income tax law. It says, which is now 320, that new act from next year. It says, when the assessee has deceased and the legal representatives continue the proceedings, the notice issued to the deceased before his demise will be deemed to have also been issued to the legal heirs at the material point in time. Which means in theory, whatever is your now 148 notice was issued to two people, factually to the proprietor and fictionally to the legal heir. I don't know why nobody's questioned this, but anyway. So if you keep this in mind, in GST do we have a provision like this? Very important. What does chapter 15 say? Chapter 15, 73, 74, 74A, 75, 76. What does it say? It says, show cause notice must be issued to the person chargeable with tax. Show cause notice must be issued to person chargeable with tax. What is legal representative? Under section 93(1)(b), person liable to discharge the tax. Is it the same? Person chargeable with tax is the proprietor. Person liable to discharge the tax, legal heir. How can show cause notice be given to the legal heir? So we had one incident where notice was issued to the wife. Reply was filed saying that your notice has been delivered. Your notice has been delivered to the residence. Your notice has been delivered but not served. So he replied back saying that the spouse is the agent of the husband, 169. With the death of the principal, agency also goes. Correct? Contract law. Agent cannot be agent where principal is gone. Correct, no? With the death of the principal, agency has gone. Then why did you write this letter? Good question. 209 of contract law says the duty of the agent is to do all those minimum things necessary to protect the interests of the deceased principal. I am only informing you. I don't have to inform you also. I am only informing you. Now you go do whatever you want. He decided to pass an order. He passed the order. He said, attach bank account. Which bank account? You understand? Please be very careful. See, officers are not interested in the law. They are only interested to finish the job and move on to next project. That's all. Doesn't matter. What reply? You know, audit proceedings, I keep asking, how many audits are being done here in Chennai? What, in each circle, what percentage? How many assessees are there in a given circle? How many audits are selected? In Karnataka, the average is 0.6%. Not even 1%. 0.6. So I ask audit officers during their training, madam, what time I will get that small paper, madam? Bangalore na chumma. Yes. So therefore, please bear in mind, our kekkur munadi kettano. Appoda madhyana kubuduvanga. So therefore, please bear in mind, when we are identifying what stand we are taking, we need to be very cautious. What are the rights and remedies available in law? When we are filing this appeal, please don't get carried away with, come on, Ashwin, come on. We have to be very careful what stand we want to take. Follow light procedure, light papers. What has to be found out? Their job. Many times I see chartered accountants lack confidence. See, first session, everybody English le pesittu ponanga. Correct? We lack that confidence. Anga poi eppadi solluvom, how to speak, how not to speak. Don't worry. And the eppadi varudho sollidunga. Now the job of the bench to decide what to do. எங்க ஒரு இங்கிலீஷே எனக்கு தெரியாது, நீ வேற இங்கிலீஷ்ல என்னென்னமோ சொல்ற. Sir, don't hesitate. What you have to say? You have to start. You have no choice. Anybody thinks that I will not get into litigation fights, I will only do advisory work, sorry. You have to get into litigation practice because everybody is getting notices. If you didn't get notice, please check, it has already come by email, you didn't open it. Everybody is going to get, no, I'm not good at English, I'm not good at I speak in Kannada, I speak in Tamil, I speak in Hindi, ek gaon mein, all those things are fine. London, party, you understand? So therefore, please bear in mind, we tend to be self-deprecating. I'm not good. I'm not good. Don't keep saying this again and again. Now it is no longer your problem, it is other people's problem. They have to figure it. But I will now. They will figure out what ultimately, what comes to our rescue is that nobody wants to sign a bad order. It is easier to say that order was wrong than to support that order, because doctrine of merger, it will come and become part of my order. State of Kerala versus Kunyamad, beautiful judgment explaining, and Datar sir has written a very beautiful piece in Bar and Bench about how Kunyamad judgment, it is time for review. There are some aspects that is not fully appreciated in that judgment, although the judgment is a beautiful judgment, some 13 different points explaining what is doctrine of merger, and sir says that it is time to look at certain new aspects. Wonderful piece, wonderful piece. So therefore, please bear in mind, the rules of procedure are there. We have to be mindful that we are all getting into that practice. We need to only familiarize ourselves with how this is being done, and it will work only on collaboration. Because that youngster in the office who's uploading the auto-populated form, Raja, apdilapa, you understand, you talk to him, help him understand what he needs to do, so that you have figured out what needs to be done. Tribunal is going to be the place where the whole law is going to unfold. I'm reminded of one decision of JK Synthetics, 132 ELT. Supreme Court said on a classification dispute of that UPS is inverter or power storage device. Supreme Court said, Tribunal is the most competent authority on classification. Once 5 judges have applied their mind, we have nothing further to say, and dismissed it. So therefore, please bear in mind, it is at tribunal where all things are going to unfold. Someone estimated that there will be 6 lakh appeals that will be filed. 6 lakh appeals will be filed whenever tribunal starts, and then year on year some more. 7,40,000 crores is estimated to be the amount of tax in dispute. It's not possible. How many cases Karthik sir will handle? Poor man. How many he will handle? All the problematic cases will give him. So therefore, please bear in mind, this is the place where we'll have to make a decision that this is not something that is not for me. And I'm very happy when madam invited me that so many people are so enthusiastic about taking part in a 2-day event focusing on litigation. This is something that you're almost there to jump into it, poga poga, avanga pazhikkuvaanga. Thank you very much.
So we invite Mr. K.
Often
Ravi
usurp
sir
authority.
to give few words.
You must tell us something on, invariably in the grounds of appeal, you find a last ground which is for these and such other grounds that may be raised during, before or during. Is that right in law? What happened? So therefore, you want to raise an additional ground, you have to go through a process of raising an additional ground, correct? You can't simply say, but where the rules provide that even an oral argument is possible, can you bring a ground?
A taxpayer's grievance about the impugned order cannot be thwarted at the threshold of the proceedings. Therefore, grounds in the beginning need to be drafted with caution, sufficiently broad-based language, but if there is a ground on an issue that is already touched upon in the existing grounds, you can certainly move those, and tribunal will find it very difficult to turn this application down. My submission is, do it. You forget what rule 112 says, it doesn't matter, you still make this application. What 112 talks about is whether new evidence can be introduced. Ground, certainly you should move it, and we'll see how the tribunal will wriggle out of this awkward situation. Put them in a spot.
Okay, now the second question. The
Easy
adjudicating
calculation.
authority or the first authority passes an order, then there's an appellate authority who passes an order. Does the appellate authority's order get merged in the first order, or is it the other way around?
The order at large before the appellate authority will, depending on what the appellate authority says, will become the order of the appellate authority, and that is now at large in the next forum. So therefore, what is come to the appellate authority, those points, when it is confirmed, will merge into the orders of the appellate authority.
Order of the original authority or appellate authority?
Original authority merges into appellate authority, appellate authority merges into tribunal's order if further on they
So
support.
the issue is, let's assume that you have not raised a very fundamental ground in your first appeal. Now, you are entitled to file an appeal against the order of the appellate authority.
Correct.
How do you get into a very fundamental ground which you did not? Because I am coming to this from one aspect of the matter which my friend must highlight. You know, there was a senior counsel by I respect a lot, and I'm sure Jatin and Karthik also will have to accept their position. He would always say an ounce of fact is better than a ton of law. That was a standard statement. He will say, bring all facts on record. However bad the facts are against you, because suppressive or very suggestive falsity will come into force if you don't put your facts. So let's assume you want to take some fundamental fact. I'll give you a simple a simple situation. You have not raised the fundamental jurisdictional ground, or you have not placed an adjudicatory fact before the first authority. Where are you stuck?
I would look at it in another light. Somebody who is interested to save the demand. I'm not saying everybody is like this, but somebody who is interested to save the demand can lay blame on my omission to sustain the demand, even though the ground being raised is worthy of consideration, and if it is considered, it will eventually turn the table in against revenue. If the motivation is to save the demand, this can become a reason for them to confirm the demand. So therefore, we should not second guess as what Sir says, and if the greats have said this, then that is something that is to be followed unquestioned. But if you have missed it, don't prejudge yourself and say nobody will now entertain this. Move it. Who knows? Who knows if that is going to find favor, and then work for your advantage.
The last is, it's not to Jatin. Jatin was talking of, I don't have the ability to talk English. I may not be able to. I'm not a good orator. I'm not a big public speaker and all that. I'll share one incident which happened in my life, but please forget it. Don't go and quote this outside, because Jatin will come out and slipper me. College, and in 1974, co-education college in Bombay. That time you did not have co-education in Chennai, not even in Bangalore. There was only one college for Sophia College for Women, which is an exclusive co-education college. My college had 900 students.
Super.
There was an elocution competition. I participated in it, and the college had a fantastic system. The entire college students will be present because we'll drag the professors. That was the interesting part of it. So the entire college was present. We were 20 of us. The person who gets the award knows that it will be announced only on that day. So and so gets the award. And the person who gives away the award is the last in the rank. And all of us are expected to come to college. I decided that day that I'll become a great speaker. I never went to any public speaking courses, but I watched speakers, and if you challenge me for the next 3 hours, I'll gas on science. You will not even know that I'm gassing. Thank you.
Thank you, sir, for all your questions. Yeah. Thank you to the speaker for the purposeful words. Your insights added great value to the session and were deeply appreciated. Your insights on the principle that treating unequals as equals would offend the requirement of reasonableness, along with your structured analysis and practical interpretation of contentious issues, provided exceptional clarity. You emphasized that our stand in tax matters must be grounded in knowledge, wisdom, rights, and remedies, together with your explanation of procedural intricacies, has greatly enhanced our understanding of the GST litigation landscape. The session was further enriched by the moments of humor you shared, making it both informative and engaging. Thank you, sir. Yeah. Members, we will now break for lunch for 25 minutes. So please enjoy your meal and Ranjit Mathani. I also request our chairman, CA Revati Raghunathan and CA Dr. Abhishek Murali, RCM, SIRC, ICA to accompany them to the desk. As a token of our respect, I invite Chairman CA Revati S. Raghunathan and CA Dr. Abhishek Murali, RCM of SIRC, to give memento to the presiding officers. I request our chairman CA Revati Raghunathan to give introduction about the presiding officers.
Just give us
About the courtroom proceedings also.
Yeah, I'll not take much time. We are already starting 20 minutes late. We want to enjoy the forthcoming GSTAT and the experience of the two presiding officers, Advocate Ranjit Mathani and Advocate Gopal Mundra, who, as per, the other speakers, immediately accepted when we reached out to them and requested them to come in as presiding officers. Sirs, thank you very, very much on behalf of everyone here. We are deeply obliged to you for having come here and taken up. And this is the first time an event like this is being organized in SIRC. So we hope this is going to be the first of many of your visits to SIRC for this program. And as I told in the morning, this synergy between the law and the chartered accountancy profession is being carried forward here also. We have 3 chartered accountants and 3 lawyers. Of course, the 3 chartered accountants are, out of the 3 chartered accountants, 2 are also lawyers, but I hope you will come in only in your CA avatar here and not as your, as the lawyers. So we want to actually showcase the synergies with which our professions can actually hold hands and go together on the professional journey, like how I told in the morning, because, unless we develop these synergies, both the professions are going to take a hit. And like Jatin sir told, so many 7.54 lakh crores is what is going to be the amount of business which is going to be generated, out of which he generously said Karthik can take a few crores and the rest is going to be shared among the lawyers and the advocates. And sessions like this is going to prepare the chartered accountants to actually take up the GSTAT practice successfully. So I would now hand over the proceedings to the MC, not taking up too much of time. Thank you once again, sirs.
Thank you.
Of course, one more heartfelt thanks to Ravi sir for enabling both our presiding officers to come here today. It was just one phone call which he did and then they both accepted. So that is the respect that everyone has for him. And in the subsidiary of subsidiary Maria, I am also basking in some reflected glory over here. Thank you very much.
Thank you, Revati ma'am, for your warm introduction. May I now request Advocate K. Ravi, past chairperson SIRC ICAI, to kindly share a few words about advocacy for 2 minutes.
First of all, I must tell you that these 2 gentlemen, I asked Karthik. He gave me the names. I said, will you talk to them? Just send them a message. And I talked to them. I sent them a message and said, boss, you have to come. Now I put them in the position of a boss. Does the boss not take instructions from the subordinate? That's his large question, which is to be answered by them and not by me. They'll have to decide. But they are here. So the answer is also available without any further elaboration by them. I don't know whether I'll talk about advocacy. That's not something which I know of, or it's not my subject, but certainly a few experiences in the tribunal or in the High Court which I should share with you. First thing, when you address somebody, please look into their eyes. Don't look away. This is the first tip I will give. Because the moment you look into their eyes, you are showing a level of confidence. If you don't look to the eyes and then I turn myself the other way around, none of you are going to. And if you're talking to a large gathering, obviously you shift your rally fan. But looking into the eyes is very, very important. This is the first tip I would give anybody. The second, whenever you're prepared for a case, please have your written notes ready. Have your written notes ready. Don't go without that. Because when you start writing, you realize where are the potholes out of which your car tire will get stuck. You know your potholes. That's the second advice which I will give, and I've been following this for ages, ever since I started my practice in the tribunal or High Court. Even there, prior to that, before CA tables also, it was always written submissions, never without a submission. In that process, you are actually strangulating him, if I may say so, subject to what my friends will say. Because he has to answer everything that is there, and if he does not answer, next level, Lordship, the questions that I've raised are not answered. This is what I said. My case law has not been considered, which is directly in my favor. Most of the case laws, largely they should know. So just don't start reading out the whole thing. Nobody is interested, and today that level of patience is not there. So therefore, quickly get to the operative portion. Please read paragraph 14 of this judgment, which starts here. I am referring to paragraph 14 on this page. This is where the principle is laid down. And be careful of your principles. Because very often I have found that they rely on a paragraph which is only an argument advanced by somebody, and the conclusion may be something different. Please be very, very careful. Don't get into that trap. See whether that is the conclusion. Now, you may have multiple decisions on the same subject. Let's assume that all of them have gone in favor of the assessee. Yet, you must find out which are the decisions which will ensure your easy ride through. Somewhere those decisions may not be perfectly listing out the reasons. So somebody on the other side can quickly point a fault. I'm sure when do I have to stop? Another 5 minutes? One more minute. Okay, I'll give you only one example. I'll give you only one more example. All of them will know. Supra says general insurance. It was a matter on service tax for the first time. Reinsurance, whether it is liable for service tax or not. Reinsurance. I had engaged senior counsel Natarajan to appear. No, he pulled out a lot of decisions. There was no precedent to this concept, because reinsurance is not a contract of insurance. It's not a contract of insurance. It's a contract simpliciter. We had to first find out that, and then he picked up decisions, and then he said he made out a list of arguments which the other side will make. He said these are the decisions they are likely to support, to use for their advantage. Therefore, we must have answers for that. So don't rely on your case. Be prepared for what the other side will demolish you. And I have heard number of, I'll leave one more example. You must also know strategy. I was appearing in 1998 in one of those most sensitive matters. You know what happened in 96. I go to the tribunal, mine is the first matter. I say first, let me list seriatim, the facts. And I go on listing. The other side, they had brought a special counsel to argue the matter, a very sensitive matter. The man beautifully argued. He said, my friend, as usual, is bluffing. I had a bad case. What do you do? I said, I am not anymore appearing in this matter. He has listed all the facts. Maybe the serial number in which he is listed is different from my number. But tell me one fact which I have said, which is not there, or which he has said and I am not there. Tell me one fact. He can't make such allegations. I have been coming to the tribunal fairly frequently. Sorry, I will not appear. Please may I adjourn it. I'll ask them to make alternative arrangements. The member said, Ravi, tomorrow, if you are upset today, tomorrow morning, first item, if you come, we'll take a decision. If you don't come, we'll dismiss the matter. I'll leave it there.
So that was the strategy, sir. Thank you so much. Yeah, brief profile about the presiding officers. Advocate Gopal Mundra, senior tax litigation expert, partner at ELP Mumbai with over 2 decades of experience in taxation and regulatory matters. Strong advocacy, represents clients before the Supreme Court, High Court and tax tribunals, AAR. Advises major Indian and multinational companies across telecom, metals, software, cement, insurance, asset management and finance, power, real estate industries. Recipient of multiple rankings including Litigation Star, Tax, Benchmark Litigation Asia Pacific, Litigation and Disputes Attorney of the Year, ITR Awards 2024, ITR World Tax Controversy and named in BW 40 Under 40 and ALB India Rising Star 2022. And about Mr. Advocate Ranjit Matani, he specializes in GST, Customs and FTP with extensive experience in VAT, Service Tax and Central Excise. He handled numerous GST litigation across adjudicatory and appellate forums and has represented clients before tribunals and courts. Consistently named as an indirect tax leader by International Tax Review from 18 to 25. A chartered accountant and lawyer, former Big Four partner, active member of IMC's Indirect Taxes Committee, has also served as an expert witness before arbitral tribunals. We request both dignitaries to kindly take up and preside over the moot court proceedings, and court master for the today's session, Mr. Vignesh, will take from here.
Manappuram Constructions, Advocate Karthik Sundaram for the counsel, for the assessee, and CA Chetan Christopher, DR.
My lords, I represent the petitioner Titanium in this matter. The brief facts are these. The petitioner is a developer and he has entered into an agreement with an entity called Meridian, who is the landowner. The entity has given certain rights to him to develop properties and has also agreed to part with the UDS, for which Titanium in turn will give built-up areas to Meridian. The central controversy is that the right given to develop lands, which then transforms into buildings, is being treated as development rights, and that is being brought to GST. We had filed a reply before the authority, which had been dismissed. Thereafter, we had filed a challenge to the respective notifications which sought to treat development rights as a taxable event, as also the notifications which brought about a reverse charge on the developer, and this matter came up before the Madras High Court. Unfortunately, the High Court had dismissed this basis the ground of alternate remedy. So my first submission would be to address the issue of
alternate remedy respect of challenge to notification.
My lords, the Writ court had dismissed both. Therefore, my first submission would be that once a notification is challenged, the issue of ultra-vires can only be decided by the constitutional courts, and therefore the writ could not have been dismissed per se. Since this honorable court has issued notice, I take it that the court is inclined to go ahead with the matter, but I would also like to submit that it is well settled law, including in the recent decision of this court in Radhakrishnan, that whenever the provisions of a statute are challenged, a writ petition is maintainable. If my lords are satisfied with that, then I will proceed to the primary issues of challenge. The constitutional challenge will have a bearing on the main issue, which is also the subject matter of the order in original. Therefore, the constitutional challenge goes hand in hand with the reply we have taken.
So, what's the finding of High Court, particularly on the constitutional validity?
My lords, the High Court said because there is an alternate remedy, they really didn't go into the issue of constitutional validity. Therefore, my lords does not even have the benefit of the ruling of the High Court because they dismissed the entire petition on the issue of alternate remedy.
So counsel, in that situation, would it not be fair on us and you to go back to the High Court?
My lords, if I'm given an opportunity to go back to the High Court, I would go back and have the matter heard. But what I would also urge my lords is, because this is a all industry issue and a national issue, and other matters are also pending where other high courts have taken a particular view. If this honorable court hears the issue, it could possibly settle the issue for the times to come.
Counsel, therefore, the question is, would you first be addressing us on the constitutionality of it and the validity of the notification, or are you looking to first talk about the...
I would first seek to address the constitutional issue, because if that is resolved in my favor, then the order in original will also have to go as my submission.
And this is pending in several other high courts as well?
It's pending in one matter before this honorable court, and it's pending in 5 or 6 other high courts.
So why don't we just tag this matter with the other matter which is pending and hear you on some other day when both the matters are clubbed together and heard together?
My lords, this matter is already ripe for hearing, and if my lord gives an order in this matter, then it would possibly also apply to the other matter. Therefore, I would only request that I be heard today, and this decision will equally apply to the other matter. The legal issues being the same, and the factual issues are not going to make any difference to the issue at hand because it's a constitutional challenge, my lords.
Counsel, I think we will let you proceed with this. With the first question, of course, being to the other side, that we are prepared to go on with this.
Yes, sir.
My lords, the primary framework which I'd like to bring to my lord's attention is that goods and services tax necessarily means that it's a tax on either goods or services, and that under our constitutional scheme, land and immovable property are treated separately. This flows from entry 49 of list 2. When we also look at the General Clauses Act 3 subclause 26, there is a specific definition of immovable property wherein any land or benefits arising out of land will be treated as immovable property. Therefore, my first submission would be that the nature of development rights per se are nothing but benefits arising out of land, and that development rights are per se nothing but land or something in the nature of immovable property. If that be so, the second question which arises is, can an immovable property per se be treated as a service? Even though my lords have not ruled on the issue of whether development rights per se are immovable property, there are decisions of the Bombay High Court which have interpreted the General Clauses Act to say that transfer of development rights are immovable property. It would apply more fully so to development rights which are not transferable. And since this flows directly from the General Clauses Act, it's my submission that development right is nothing but a benefit arising out of land which is immovable in nature. If my lords are satisfied on that, I would like to proceed to the second issue as to whether immovable property at all can be treated as a service.
Counsel, before you go ahead, the question is, the rights that you are talking about, are those the only kind of rights that one sees in land and immovable property?
My lords, the manner in which land has been interpreted, including in the recent ruling of the 9-judge bench of this court, is that any benefits arising out of land or any rights arising out of land are referable to land as a unit. Therefore, the court has interpreted even mineral rights per se, which are something in the subsoil, to be land per se, which can also be brought to tax under entry 49 of list 2 of the Constitution. And that would also includes all rights above land. Therefore, my submission is that any benefits arising out of land per se would be treated as land. And if I was to look at a service, it can only be a service on land or in relation to land, like a construction service. Therefore, a benefit arising out of land cannot separately be treated as a service per se.
Just to add what my brother stated, benefit arising out of land is the expression what you are using again and again, right? Renting of immovable property, that is also something which is being taxed as service. Is that also not a benefit arising out of the land which is being taxed? Then how is your situation different than this?
Counsel, before you go ahead, I'm also curious as to whether lease rights is also then going to be carved out on the same principles
same
that you are
basis.
talking about.
My lords.
And we already had a series of decision earlier when the constitutional validity in relation to the renting and all were challenged long back. So whether your case is different than that?
My lords, my submission would be this, that any benefit arising out of land is immovable property per se. From that perspective, a development right is similar to the right to lease. The issue in this case is only a development right, but the conclusion which my lords may take will have a bearing on the other issue. The other issue is a separate and distinct issue pending before my lords. But if the conclusion is that a benefit out of land such as a development right is nothing but land, it will have a bearing on the other issue also, and my lord's decision in this matter will go a long way towards resolving that. But given that this is specific to development rights, I would like to address my arguments on this.
So counsel, therefore there are 2 points and propositions, and do tell me if these are your propositions. One is whether development rights constitutes benefits of land and therefore land indirectly, and the other point of question is whether development rights by itself, considered in maybe vacuum, is a service.
My lords,
are there 2 points that we need to dissect?
No, my submission is this, that development rights are nothing but benefits arising out of land, and that benefits arising out of land per definition is nothing but immovable property. Therefore, consequently, development rights or any transfer of development rights is only giving away the benefits of land being immovable in nature. It cannot be constituted as a service. What may be constituted as a service is construction on land, which may be an activity on land. Therefore, if I am disposing of a part of a right which I have, development rights being a part of the rights which I have in immovable property, that does not change the nature of property per se. It continues to remove immovable in nature, and that doesn't become a service. If I do any activity such as construction services on land or in relation to land, that can probably be treated as a service.
So counsel, the question again is that when we consider the development rights, if it does constitute service and therefore comes within the ambit of services as defined in the Goods and Services Tax Act, do we then not have a situation where it must be taxed? Where does the carve out come from which you are laboring?
That is why, my lords, I have challenged 2 things. One is the definition of service under the Goods and Services Tax Act, as also the notification. My submission is that though the definition of service says it's anything other than movable property, nomen juris is that service is always an activity other than immovable property per se. The General Clauses Act also defines benefit arising out of land as being immovable property. Also, under our constitutional scheme, immovable property, that is land as a unit, goods and services are always treated separately. If you look at the scheme under Article 246A, it deals only with goods and services, goods being defined under Article 366 subclause 12, and land has been separately used in entry 49 of list 2 and judicially interpreted, and the definition of General Clauses Act also taken to bear. Therefore, my primary argument is a challenge to the definition of services. One, to say that services should be read down in a manner to mean anything other than goods, but does not include immovable property per se. And 2, consequently, the notifications.
Mr. Counsel, are you not relying too much on General Clauses Act, wherein you have specific definitions in the law itself, more particularly about the services and all, which says anything other than the goods? So thereby, if there is a specific definition under the Act, why should not we follow the same? And why there is a need to revert to the General Clauses Act?
My reference to the General Clauses Act is only to demonstrate the principle of nomen juris, which also takes us back to a constitutional scheme that land and immovable property under the Constitution always has a different connotation from service, which came under first entry 97 of list 1 and later entry 92, which specifically used the word services. Therefore, the understanding of services per se has always been something movable or intangible other than immovable property per se, which is also why I am challenging the definition of services to say that you can have a deeming fiction to deem something which is not a service to be a service, but under the present definition of services, there is no deeming fiction. Therefore, to read it in a manner which will include immovable property, which falls under another entry, would be unconstitutional. And if I would like to raise the argument to the highest, would probably be violative of the basic structure of the Constitution.
Council, therefore, you are going as far as to say that the recommendation that the GST Council made, and in therefore legislating the Central Goods and Services Tax Act, is all gone beyond the constitutional framework. Because essentially, when you bring to question the definition of service, the position is that the GST Council was the all-encompassing power that had the ability to recommend and effectively have legislated the law, which they did. There's a definition for service. Now, it may not be something that is nomen juris, as you say, but why is it that we must not accept that for what it is?
And just to add what my brothers said, immovable property, be it a land or building, it confers or involves in itself a bundle of rights. You cannot just take one thread out of that bundle and say that this is also immovable property, and this is also therefore out of the scope of GST. If that be the case, then renting, leasing, all this will go out of GST network. So our first threshold which needs to be cleared is that whether this can indeed be considered as immovable property, and secondly, if, as you have earlier pointed out, this is something which is in nature or akin to renting only, then if that be the case, that particular aspect has already been examined and concluded by the courts. So how do we really move ahead from this particular point? That is the most critical element right now.
My submission on both the issues are this. The recommendation of the GST Council was that GST was envisaged as a tax only on goods and services, and it subsumed all previous taxes. Under the erstwhile service tax regime or the VAT regime, a transaction of development right or a transaction in immovable property was per se not taxed. The GST Council also sought it fit to keep sale of immovable property outside the purview of GST, only for the reasons that they didn't want to bring in immovable property within GST. The second submission is that the recommendations of the GST Council, even if it said otherwise, are only recommendatory in nature and not binding, in line with this court's decision in Mohit Minerals. Therefore, today what I am stating is that the definition of service, insofar as it seeks to exclude some elements of immovable property in terms of third schedule, but bring in other elements of immovable property, is not only against the constitutional framework, but is also manifestly arbitrary. Now, coming to the other questions which my lords had raised, once it is a bundle of rights, my submission is that any of those bundle of rights, be it either a right in development property or a right to sell or a right to lease, will fall outside the framework of the definition of service, and therefore if it's held that development rights cannot be taxable, so lease can also not be taxable in that instance, which is why I had earlier stated that the decisions which my lord takes may have ramifications for a larger bundle of rights, the principle being the same.
So in your fact, is it a residential property, or the redevelopment is going to be a residential one or the commercial one?
My lord, it is a commercial property, but on law this fact will not make any difference because I am only arguing on a legal proposition.
No, why I'm asking this question is that if it is a residential, it already enjoys exemption. So is this not just merely an academic exercise for us to waste public money?
My lords, it is a commercial property, and two, I would not term it as an academic exercise merely because, my lords, an exemption is only a suspension of a levy. The levy is always there. Tomorrow, if they decide to bring in the tax again, I will again have to come through the route. Therefore, once this issue is decided, and given that this may also have a repercussion on other issues, I would urge my lords to look at the issue.
Counsel, would you just be kind enough to, therefore, paraphrase the arguments you're going to make? Don't make the arguments, just summarize and paraphrase the
My lords,
points that you are going to urge.
in summary, my arguments are the following. My challenge is to 1, the definition of service, and to 2, the subordinate legislation which makes a developer liable to pay tax on development rights under the reverse charge mechanism. My first argument is that service has a defined connotation under the Constitution which excludes immovable property. Therefore, under a legislation, you can't have a...
Counsel, service excludes immovable property. Would you please elaborate? Can we look at the definition, please?
Under the Constitution, goods is defined. Service was used in the context of entry 97 and in the context of entry 92C. Therefore, when I said it has a particular connotation, the way it was interpreted is service was something other than good, but excluded land, building and immovable property, which are subject matter of entry 49. Therefore, it's the interpretation given by the court which I'm referring to.
So, therefore, what you are suggesting is that we, for this matter, look at the definition given to us in the Constitution while almost ignoring the one given to us in the Central Service Tax Act. My lords?
If there is a definition in an act which is not a deemed definition and which is against the concepts set out under the Constitution, as well as the concept of how service in nomen juris is understood, that gives me a good ground to challenge, and I am in a challenge before a writ petition. In the judgment in Gannon Dunkerley in 1960s, as my lord is well aware, they had looked at the definition of sale as emanating from the Sale of Goods Act, applied it as nomen juris, and applied it as to whether the definitions under the VAT Act fit within such definition of sale or not. I am applying the same principles to this issue.
Very well, you may continue on this.
Please go ahead.
Yeah, please go ahead.
My third submission which I sought to canvass is that even if the definition of service is not read down, or if the definition of service insofar as it seeks to tax immovable property is not set aside, even on a harmonious construction of the definition of service and Schedule 3, it would arise that they don't wish to tax the sale of immovable property. Even though development rights is not specifically defined, there is no entry to tax development rights or any manifest intention to tax development rights. It only comes forth in the notification. If one right relating to immovable property is not sought to be taxed, it also evidences the legislative intention that services are to exclude any right in relation to immovable property. If that is so, then any subordinate legislation which tries to bring about a tax which is not permissible under the parent legislation is contra the parent legislation, and therefore the notifications on that aspect should be set aside. In this regard, I would like to place reliance on a recent decision of this court in Naresh Chandra vs. ICAI, where they have discussed this issue. The relevant finding is at para 37. Since it had been rendered by one of my lords, I'm sure my lords is well aware of that decision.
Yeah, Counsel, you would like to add? Are you prepared?
Yes, ma'am. My lord, I see that court is granting my learned friend the indulgence to be heard on merits. This is the very same approach adopted in the High Court, where facts were selectively presented, provisions of the law were withheld as part of the submissions. So therefore, I am aghast that the same strategy is being adopted in this forum also. The indulgence that my lords granted my learned friend, I'm happy to allow it to and be part of it, to give quietus to this whole issue that is being raised in high courts as well. My lord, we'll take a few steps back and understand what the facts are. The facts are, there is a joint development agreement, and a joint development agreement is not an absolute sale deed. That it is nobody's case that agreements which are joint development agreements are synonymous with sale deed. We have Suraj Lamps, Thomson Press, K. Gopi, all the judgments of this court that say that to effect a sale, an absolute sale deed and nothing less is sufficient.
So how is this relevant to this?
This is not a sale deed, this is a joint development agreement. Now the terms of the joint development agreement, my learned friend says, he has been put in possession of the land, therefore the sale deed that will eventually be executed is an empty formality to conclude what has already been concluded at the time of JDA. My submission there, my lord, is I'm tracing this whole argument to section 5 of transfer property law, where it talks about transfer of property means an act by which a living person conveys property in present or in future to one or more other living person. My lords are fully seized of the judicial authority in Jugal Kishore Saraf versus Raw Cotton Company in 1955, which says that in future qualifies the conveys and not the property. In other words, property in future cannot be conveyed in present. The subject matter of the sale deed in the future is not land undeveloped. The subject matter of transfer in the future is going to be undivided share in the land along with the constructed unit to such persons who may arrive in the future. So my learned friend is saying that this is as good as sale. There is no such thing as good as sale. My submission there is,
before getting into whether it's sale or anything else, the first condition what the other side is mentioning is that the development right is nothing but an immovable property. If we can clear that, then maybe other aspects may fall in domino effect. So let's first of all discuss that.
Obliged,
Do you have anything to say on that?
my lord, the exclusion that my learned friend is claiming is on two fronts. First, Schedule 3 of the GST law carves out sale of land, and they are relying on that entry to say that sale of land will include all rights associated with immovable property. Nobody can change the statutory language from land to immovable property. Land is one of the several aspects that an immovable property comprises of, as my lords brought out the aspects of benefits arising of land, profit, effrontery, etc. The second aspect, my lord, is service is not defined in the constitution is a submission. My lord, we have to trace this GST law not to Article 246 but Article 246A. All the references to the 7th schedule, the entries in the 7th schedule are all relevant if the tax is flowing from 246, but this tax is flowing from 246A, and the legislative labor in introducing a constitutional amendment is being glossed over. Service is defined in 366(26)A, and the same definition we find in section 202 also, to say service means anything other than goods. So service, what is being canvassed here is as if it is a verb, but service is not a verb in GST. Service is a noun. If it is not goods, it is a service. There is no challenge here or before the High Court that immovable property is outside the realm of 246A. All the arguments presented revolved around 246. So therefore my submission is that land is immovable property, joint development agreement is immovable property, but what is carved out from incidence of GST is land and land only, and not the entire universe of what makes up immovable property. As my lords rightly brought out, the other kinds of transactions, whether it's lease and so on and so forth involving immovable property, all those have been taxed, and like Lords rightly said, issue has been considered and settled that all those other intangible immovable property rights have been rightly taxed. One last submission on this aspect of the judgments that are being cited. The same Gannon Dunkerley in AR 1958 SC 560 says that sale is nomen juris. Sale has to be understood as how sale is understood in Sale of Goods Act 1930. Judgments under stamp duty, this court at that time very categorically said have no application when you are examining sale, because the purpose of using expressions in stamp duty legislations is to determine the classification to tax the instrument and not give a character to the nature of the transaction, and that judgment has laid the law for since 1958 for us to follow. So therefore my submission is that it is immovable property but not the kind that falls within Schedule 3, so therefore it is squarely taxable and traceable to 246 email.
So what according to you, Mr. Christopher, falls within this concept of Schedule 3?
The language of Schedule 3 in para 5 is very clear. Sale of land. Sale cannot be anything other than sale. Land cannot be anything more than land. So that is the narrow conspectus within which the council has approved, Parliament has enacted, that this is the carve-out.
That is why council, he is challenging the very definition for services. So what do you have to say about that?
My submission, my lord, is these are matters relating to facts concerning the interpretation of their contract, whether that JDA is enforceable, etc. This is a ploy to satisfy the question of maintainability, which they failed before the High Court, and they're trying the same thing here, just to challenge the vires of any provision to reach this court. Actually, there is no issue with maintainability itself is in question, because there is, in all the arguments I've heard, there's no question of challenge, because they're relying on definitions traceable to 246 and not 246A. If they confine the whole inquiry to 246A, service is defined, goods are defined, legislation is passed, the whole process has been followed, so therefore there is no reason to come here.
In which situation, Mr. Christopher, then we need not be here? If we
I'm
are
with you, my lord.
If we are not,
I'll
if
be
we are
glad
not
if it's
required-
dismissed straight away, my
if
lord.
we are not required to adjudicate on an issue where a law is challenged and constitutionality questions are raised, then, and we go by what is given in a given statute, in a definition, in this case services, we will have nothing to do and say in this case, and therefore all matters will then simply have to be addressed and concluded in that fashion.
My lords have much to say in the matter of maintainability itself, because merely conflating an issue on vires of the provisions does not satisfy without bringing home material to say that the vires is really in question. This is what the High Court was also satisfied, that there is nothing to question, and
Counsel,
therefore dismiss, my lord.
I think I was informed that the High Court had no observations on the vires, and they simply relegated them to alternate remedy.
Yes, my lord.
So in that situation, wouldn't it be fair, and in the larger interest of everything that's going on in the different high courts, that this question and the constitutional validity of this provision of definition and these notifications are dealt with? So what do you have to say about that specific aspect? And question is that when they say that the services are to be seen as nomen juris, whilst the GST Act has a definition, how do you sort of counter that? How do you look at that?
Yes. I'm obliged, my lord. Service is nomen juris. Service, we have to be mindful, is not a verb, it's a noun.
Counsel, I'm not sure I'm convinced with that. Would you please
I will submit. 366(26)(a) defines service as, service means anything other than goods. So to say what is service as nomen juris, we have to find a legislation where service is otherwise defined. There is no other legislation where we can go to other than Finance Act 94. We should not go there for the reason that when the 101st constitutional amendment was passed, the taxing regime cleaved into two different articles, 246 and 246A. So anything traceable to 246 should not be pressed into service to assist in examining questions that are traceable not to 246 but 246A. If we confine ourselves to 246A, there is no definition of service in any other legislation barring 366(26)A, which is mirrored here, madam. So therefore, that legislative language sufficiently occupies all the entries touching immovable property also.
Okay.
My lord, the next aspect about the JDA I want to make a mention, because in the submissions itself it is stated that it is effectively transfer of property, therefore it should not be taxed. The clauses that are available in the petition, it says this agreement can be terminated. My lord, if we examine section 54 of transfer of property law, all that a developer who has interest in this immovable property under a JDA, he is nothing but his agency coupled with interest under 202 of contract law. All that he can do is secure his interest and seek specific performance. It is not permitted for him to claim absolute title to the exclusion of the owner. Had the owner been excluded, then the owner would never have to come in and execute the sale deed in the future. If the clauses of the joint development agreement have to be treated as enforceable on all fours, then the clause on termination will be rendered odious by the very arguments that they are advancing, saying that the sale deed is only a formality. Therefore, if it is not to be considered as absolute sale deed, which it can't be, all the clauses itself are against them to say to make this claim that it is akin to absolute transfer of property and it should be out of GST. It's not the way it is being presented.
But Mr. Counsel, the notifications which are impugned in this particular case explicitly points out or lays down a levy on the transfer of development right.
Yes.
It very well mention promoter developer, it very well mention landowner developer. These are the expressions which are defined in the notification itself. So without going into what is the content of sales deed or otherwise, what we understand or the bench understand is there is a levy, there is a challenge to this particular notification itself, whereby the transfer of development right by the landowner promoter to the development promoter is something which is the subject matter of this dispute. So let's not get into whatever the contract they have entered into, whether it amounts to sale or doesn't amount to sale, or it's a contract of sale or an agreement to sale. We did not get into this. It's simply the notification and the wording which are the subject matter of this challenge.
Oblige, my lord. If we get into the very notification itself, the notification says that this is a service. Govind Saran, Ganga Saran requires 4 ingredients to be placed. All the 4 ingredients are satisfied by the notification. The petition challenges that the machinery provisions are absent for valuation. Valuation very clearly, the law says that it is under section 15(5). So therefore, the valuation machinery provision has been provided. In Gujarat High Court in Manish Bhai Munjal Bhatt's decision in para 55, this question came up whether there could be some mischief in allocating values between the construction agreement and the land, and the court was pleased to state that there are investigative powers to stop such misapplication of law. As the provisions stand, the abatement that is allowed, read with 15(5), is sufficient to meet the ends of Schedule 3. Therefore, there is nothing within the scheme traceable only up to 246A that has anything. Even so far, we have not heard anything to say that that is ultra vires the statutory provision.
The judgment you just cited, Mr. Counsel, what was the outcome and what was the law laid down by the High Court in that case?
My lord, the court was put a question to say that this 1/3 abatement is arbitrary, relying on Wipro's case in customs law to say this 1/3 cannot be the same for everybody. And the court said, fair enough, if it is not 1/3, find something else. But abatement is valid, and in the absence of an alternate based on actuals, We will go with 1/3 is what the court was pleased to say.
Basically, the court read down.
My lord, if I may submit, the court did not read down the provision. It said, in case there is abuse, there is machinery to arrest that. Therefore, the provisions are valid.
One more thing goes in their favor. If you see Schedule 2, Entry 5, wherein it talks about supply of services related to construction or immovable property. 5B talks about a transaction whereby there is an intention of sale. So whether 5B will come to support their case?
My lord, 5B is not germane to this case at all. What is the subject matter of dispute here is the transfer of development rights by the landowner to the developer and not the construction services by the developer to the landowner or to independent buyers. So 5B deals with the further supply that they are yet to carry out. That is not part of the dispute. The dispute is the first transaction between the landowner and the developer, whether that is liable to tax, and if it is liable to tax, they are the burden is on them under reverse.
So, Mr. Counsel, therefore, for the benefit of everyone, this JDA that we are talking about, it has 2 supplies, is your proposition?
My lord, in a JDA, there are 4 supplies. I will.
Please elaborate.
I will elaborate. I have a chart here, my lord. I have a chart here. My lords will be able to see this. There is, in a barter or an exchange, one supply forms the consideration for the other supply. There is a single transaction of barter lies embedded 2 supplies. In a joint development agreement, inter se landowner and developer, there are 2 supplies. One for the supply of development rights, which forms consideration for the construction services to be provided by the developer back to the landowner. The terms of their arrangement is that some number of units that are eventually constructed will fall to their respective shares, which they can in turn further sell to third parties. So therefore, in a joint development, the whole scheme that developers and landowners undertake is to derive 4 supplies and out of the 2 sets of units that come to be established at the time of completion.
Mr. Counsel, you are saying there are 2 supplies which constitute a barter, whereas you earlier mentioned there were 4 supplies which should constitute 2 barters. So,
my lord, in this image, what I've said, between the landowner and developer, there are 2 supplies in one exchange transaction: supply of development rights and supply of construction services. At the end of this joint development, both parties will be left with, if I recall the terms right, 35% and 65% is the sharing ratio. If you assume 100 units will be constructed, the landowner will end up with 35 constructed units. The developer will end up with 65 constructed units, which they will in turn further supply to independent buyers. So in a joint development, it is in the contemplation of the parties to come up with 4 supplies for the purposes of GST. Although optically it looks like one contiguous transaction, in GST there are 4 transactions.
But there is one aspect to it. You yourself mentioned that they both are coming together to have this entire redevelopment project. The notification itself refers both the parties as promoter, landowner promoter and developer promoter.
Yes.
Even in many RERA regulations at state level, these are regarded as co-promoter.
Yes, ma'am.
If these are co-promoter, and if it is something which is in nature of a joint venture, then whether the transaction inter se indeed a transaction for the purpose of tax, and at this stage I'll remind you of the decision in case of Majgaon Dock and the other cases wherein the inter se, when there is no transaction as such, when it's a case of joint venture or where there is a case of association of person, whether that can itself be subject to tax.
Counsel, before you go, it is to you, but I would like to know first from counsel for the petitioner whether it is your case that there is a association of persons or a joint venture in this situation?
My lords, in this,
Actually, what is your submission?
factually, my case is not that it's a joint venture or an association of persons, but on valuation, my case is that the consideration for development rights, if at all, was designated as being ₹1. And what the Gujarat High Court in Maganbai case said is if the actual value is available, you go to the actual value. If not, then you go to 1/3. I had designated the development rights as being ₹1 and the sale of land as being the 35% built up area. They have also taken the value of the sale of the land and not gone to development rights. Therefore, my first case is that development rights are not taxable. If it goes against me, then they can only identify ₹1 as the consideration towards development rights and seek to tax that. If they seek to tax the entire value, what they are seeking to tax is the value of sale of land, which is specifically excluded under Schedule 3. On this, since this also has repercussions under income tax law, I am not taking a position that it is a JV or an AOP.
Counsel, what do you have to say about the fact of joint venture or not?
My lord, it's the petitioner's case that they are not a AOP. So therefore, the entire jurisprudence that is available in the case of AOP, partnership firm, mutuality is out. They don't have any shelter. They're not even taking shelter there. They're saying that they are acting at arm's length with each other. Now what is advanced is that for the development rights, the consideration is ₹1 plus, consideration, if we trace back to 231 here and 2D in contract law.
Consideration piece, we are fully
Entire-
aligned.
yes.
We don't have any issue over there. The question here is, your notification itself regard them as promoter, both the parties. RERA regulation regards both the party as co-promoters. If that is the case, then the entire redevelopment, two parties are co-promoter. Then by operation of law, is there anything which is applied by one party to another in the case of the entire venture? You may not call it a joint venture, but this is something which both of them are jointly taking it forward.
I am obliged to answer that. My lord, now if we look at taxation law and compare that with RERA legislations, they are not comparable. For the reason, RERA is a welfare statute. They will not examine the fine niceties of contracts between the two parties because vicariously they want to hold both of them jointly and severally accountable because the other person they are speaking for is having unequal bargaining power, the individual home buyer. So therefore, what they are designated as in RERA is for purpose of RERA, but for taxation, it is not for anyone to go into what was their intention or attempt to rewrite the contract, but simply read the contract and let the tax consequences follow. So therefore, in this notification, my lords are making reference to 4th proviso to the amendment to 11/17 that came by 3/19. The amendment says, inter se developer promoter and landowner promoter, the terms are used so as to enable the landowner promoter to claim input tax credit, which is not available to developer promoter. So for the limited purposes of creating a machinery to identify their different roles. One is the developer who never had land, who invests all the money and does the development. Other has the land and does not have the wherewithal to develop. To create distinctions, these differences are drafted in the legislation to do the very thing that my friend is complaining is not there in the law, that is to create a machinery provision.
Do you have anything else to add?
My lord,
Counsel, before you go ahead, just going back to the submission you made earlier, that there is 4 transactions and 2 barters and
Yes.
so on and so forth. The question is, you did mention that as a outcome of the activity that they would do for themselves, it would be effectively self-service in that sense, that they would get 35 or 65% of the share. Now, what they ultimately garner, therefore, is immovable property, because on that land, they have gone up and constructed, whatever be those units, and they have the ability and freedom to sell that, and that's a subsequent sale. Now, if by virtue of that act, there is immovable property in question, why is it that they should have to bear GST? At least to the extent of that quantum of area that is demarcated to them, or value, in terms of value if it is so, that they are to garner?
Yes, my lord. I'm reminded of CIT versus Motor and General Stores, where this honorable court was pleased in 1968 to say that there is no scope in tax legislations to go into what is the substance of the transaction. What is necessary at every time a transaction is entered into is to examine whether that transaction, not the entire transaction after, with the benefit of hindsight, looking at it 4 years in the future as to what all transpired, at every point in time, the date they entered into joint development agreement, the date they entered into area share agreement, the date they got commencement, the date they got completion, at each point, is there an incidence or not? Has the parties exposed themselves to the treatment of law? If so, the consequences should be complied. They cannot enter into contract in one form and, to suit their conveniences after a lapse of time, come back and say ultimately this is that. This is like that Socrates syllogism to say that a man is mortal, Socrates is also a man, therefore Socrates is mortal. They're trying to prove their answer by formula that they are only inventing. My submission is that at each point in time we have to see the treatment of law.
Thank you, Counsel. Counsel, do you need to rebut?
Not the only
Counsel,
two.
Just be brief,
just 2 minutes, please.
Yes, only 2 issues I would like to bring to my Lord's attention is that they had placed reliance on the Suraj Lamp decisions, which is in the context of stamp duty. The council had also submitted that stamp duty is very different from the law relating to services. Therefore, as per their own submissions, they cannot place reliance on Suraj lamps. Number 2, the law is well settled by this court that the commercial transaction needs to be looked at. And even though I'm not a JV per se, the commercial transaction in essence is only 2 transactions. Construction services, for which UDS is being given. Development right is only a part of the ultimate transactions, as my lords has rightly held, which leads to construction, which gives a right or the land on which they will construct, for which I get sale of land. Therefore, there are only 2 transactions when we look at the substance of the issue. And in tax matters, substance should always be looked over and above the form of the transaction. With this, I conclude my submissions.
So both the counsels give you a written submission, should not exceed 3 pages within a week's time. We reserve it for the timing and will pronounce it in due course.
Oblige.
Oblige.
So may I call the next case?
Just thank you so much. I would like to thank Antra who framed this problem, and also Manikandan who helped with the previous presentation. Antra and Manikandan, thank you. So if any of you have any doubts on this problem or on the law relating to writ petitions, you know who to contact now. And since this was a constitutional challenge, this matter was before the Supreme Court because the tribunal does not hear constitutional challenges. Now, the same members, unfortunately, they have been demoted today. They will sit as a part of the GSTAT and we'll take up the matters before the GSTAT. It was before the Supreme Court so that all of you would get a flavor of how constitutional challenges work. And in the first presentation, we had discussed that a constitutional challenge is an exception to the alternate remedy theory. So just to show you that in practice, now, even though they may supposedly be demoted, I think the standard of questions and the standard of judging will be the same. Over to them. Thank you.
Now the next case, SLJ Industries, CA Manikandan.
My lords, I'm the proxy counsel for the appellant in this matter. Unfortunately, the counsel is on record is unable to be present here today. Therefore, I request for a short adjournment, my lords.
What is this issue all about?
My lord, I'm unaware as I'm the proxy
Where is
counsel
the
on the
file?
matter, my lord. Unfortunately, I was informed just
You
prior
cannot
to entering
come to
this
the
court,
court
my lord.
like this without file, without even knowing what is the issue involved, and just take time.
My sincerest apologies, my lord. The circumstances were extraordinary. Otherwise, I would not appear.
Where is the
this court.
counsel who is to argue?
My lord, the counsel on record, Mr. Manikandan, has unfortunately fallen ill, my lord, which is why he was unable to appear
What
today.
has happened?
He's come down with COVID, my lord.
In all fairness, it is not a laughing matter. Counsel, I do believe next time you would come with the brief and
Yes, my
better
lord.
instructions.
Yes, my lord.
And if next time the counsel is not available, you need to argue the matter. Prepare
ma'am.
yourself accordingly.
Yes, my lord. Obliged, my lords.
The next case, Shiva Constructions Private Limited, CA Shanmuga Priya Counsel for the appellate.
No, madam. Shanmuga Priya, representing Siva Constructions Private Limited. So,
You are?
chartered accountant.
We can't
Represent-
see you. You are not in the dress code. We can't even see you.
Sorry, my lord.
Is your authorization on the file?
Yeah, it has been filed, my lord. Yeah, came from the airport urgently. Sorry, so couldn't come on that air.
We are going to dismiss this
Oh,
petition
Sure.
itself, because for the bench, anyone who represents the case or has to say anything without the proper dress code, we can't just see that. So we will dismiss it ex parte.
apologies, my lord. You should
Rules and regulations exist for them to be followed.
exactly. Shh. Can you reconsider
What to reconsider?
the petition?
But are you ready to argue the matter?
No, I need adjournment.
But the problem will remain the same. We'll not be able to see you.
We'll dismiss this. We'll dismiss this.
Thank you.
The next case, Industrial Stores Trading Company, CA Deepika Ganesan for the appellate.
My lordship, the matter is ready. I respectfully request you for a short passover, as my senior counsel is in the other case again for another matter.
What is the issue?
So the issue is with regard to reversal of ITC.
Where is the file? This is the second case happening today. Counsels are coming and having no file with them. We can't tolerate this in our court.
Apologies, my lord. So he'll be appearing shortly.
Very well, pass over.
Much obliged. Thank you.
The next case, Chennai Traders Private Limited, Advocate Jayalakshmi for the appellate and CA Sharda Hariharan for DR.
Yes.
Would you also serve the other side?
27 pages written submission.
Apologies, my lord, but it's a case that involves quite a lot of issues, my lord, and therefore it's just
How many issues?
around 10 issues, my lord, with citations that have been, just the relevant portions have been extracted in each of the pages.
Should
If
we
I may
hear
just-
it on some other day when the bench is slightly light on other matters?
My lord,
It's 27 pages written submission.
Why would you extract the judgment paragraphs in a written submission?
just for the convenience, because the appeal papers were very
Counsel,
limited.
this is far more inconvenient when we are going
Apologies,
to
Madam.
handle, this large set of papers.
Apologies, my lord. I try and make the case submissions as short as possible.
Very
my
well,
lord,
you
if-
start, but maybe after the matter is over, I would request if you can have 3-pager, maximum 4 pages, not more than 4 pages written synopsis.
Obliged, my lord. My lord, the appellant is involved in trading activity, my lord. He is a supplier under the GST and is registered. The notice has been issued for the period between 2007. Yes, ma'am. Obliged. The notice has been issued for the period between 2017, my lord, to 2020-2021. My lord, and the show cause notice is consequence of the
Counsel,
DG.
how many show cause notices?
Single show cause notice, my lord. There is bunching of cases here. The show cause notice is in consequence of
And how many orders in original?
a single order in original, my lord, has been passed for all the years put together. If I may continue, my lord, the show cause notice is a consequence of a DGARM report that has given a report stating that the supplier is non-existent, and therefore, my
What
lord,
is the DGA?
DGARM is Director General of Analytical and Risk Management, my lord, where it is an internal body that conducts risk analysis to see the red flags in the supplier list, my lord, if there is any tax evasion that is happening, or if the potential risky suppliers are identified. So, my lord, merely based on the DGARM report and without any solid proof or any evidence negating the actual transactions that have been taken place between the period 2017 to 2021, this notice has been issued, my lord, and the peculiar points in this notice is that they do not dispute the fact that the ITC is duly reflected in 2A. They do not dispute the fact that I have an output, the appellant has an output supply, and my compliances have been intact, my lord. My lord-
Counsel, can you first please help us
Yes, ma'am.
understand how many issues are there that we are dealing with?
My lord,
Not questions, issues.
yes, ma'am. We have bifurcated into jurisdictional issue and on merits, my lord. Jurisdictional issue, the main issue is with regard to bunching of cases, my lord. I mean, bunching of tax periods, my lord. And then with regard to non-invocation of the relevant provisions, because when there is a specific provision, a general provision has been invoked, my lord, and therefore that
All
makes
of this is in respect of a single transaction.
yes, my lord. A single
The
supplier.
source of the controversy is one transaction or several such transactions.
Several such transactions, my lord, with a single supplier, whom subsequently the DGARM
Counsel,
report.
you should have told us this earlier, that this is
But
the
if this is a
question in short.
jurisdiction issue, go to High Court. Why have come to GSTAT?
My lord,
The
if-
jurisdictional issue.
My lord, it also involves quite a few issues on merit.
So you
and
are not
with
pressing
regard
So
to,
the
are you
jurisdiction?
pressing the jurisdictional issue or not?
yes, my lord, we are pressing the jurisdictional issue
Because
as well,
we
my lord.
don't have the power of Article 226.
How are we to address it?
Agreed, my lord, but
The jurisdiction doesn't lie with us. Can I assume jurisdiction?
my lord,
As
if
a
I may only,
tribunal, am I empowered to assume jurisdiction in this fashion?
my lord, if I may only submit that the jurisdictional issue per se, my lord, with regard to bunching of notices, the main problem here is that a few high courts have allowed bunching and held it to be legal, my lord. And therefore, we do not want that to stand as a detriment in canvassing our merits. Our merits purely is also
So
with
let's
regard to the
discuss on
fact.
merit.
So
Yes,
counsel, then let's look at
Let's focus on merit of the case.
if I may take my lords to my lord, in the present case, the show cause notice is purely based on the DGARM report, my lord. There has been no investigation that has been conducted, and it is a settled fact that I have produced the invoice copies, I have produced the bank transfer details. The supply has been reflected in the 2A, and I have also produced e-way bills and other ledger extracts along with chartered accountant certification to show the genuineness of the transactions, my lord. And therefore, with regard to the compliance under 16.2, all of these documents that I ought to have been produced is all in place, my lord. And therefore,
Counsel, two questions
yes, my
before
lord.
you proceed. First is, what is the consequence of this being a DGARM show cause notice based on the DGARM's report and not a investigation by the department in itself? What is the consequence of that?
My lord, the consequence is that the DGARM report has only red flagged the supplier and not me. The report does not
But
state.
that's why your ITC is sought to be denied.
So
But
what is the allegation?
the
Precisely
allegation is
simple
that
words, what are
the allegation is that, my lord, the supplier's registration has been retrospectively cancelled, and therefore the claim is that the supplier is non-est from day one of the GST, and therefore my bona fide transactions that I have made between 2017 to 2021 is now alleged to be illegitimate or fictitious
the
transactions.
pure question here is whether the supplier was in existence or not, and whether the supplies were made or not. That's the
Yes.
basic fulcrum of this entire process.
Yes.
Right.
How did they deal with the material that you just mentioned in terms of the invoice?
They have not considered any material that
Not considered, meaning?
They have not, though they have taken it on record, they have not given any finding to that effect, my lord, and they merely say that the matching of GSTR 2A and the reflection thereof, the auto-populated reflection thereof, is not to be considered, and therefore they say they say it's undisputed. I mean, though it is undisputed, they are disregarding it, stating that it's just a staged transaction, which we have ensured that 2A compliance is there because it's all paper transactions, my lord.
So what do you have to say about that? If it is a paper transaction, then
No, as per 16.2, my lord, we have all the detail. It's not a
in
mere
respect of a
reflection
paper
alone.
transaction, also all the documents would be available.
No, my lord, but we are able to establish here, including the e-way
Do
bill.
you have the LR copies with you?
My lord, we can produce it before my lords, my lord.
Have
It
you
is available.
produced it before the lower authorities?
We have submitted all the documents that we have submitted.
What about the e-way bills? Does it mention LR? Is there
Yes,
any
madam.
finding whether these truck numbers are genuine or not?
The impugned order is silent about it, my lord, but the e-way bill has been duly produced, my lord. All the documents containing the
And
entire
the e-way
details have
bill
been.
mentions the truck numbers also, lorry
Yes, madam.
numbers
Yes,
also.
madam. Yes, madam. And therefore, until the DGARM report was issued, there is no question of bona fides of the transaction at all. At no point of time during our submission of our 3B, etc., we have shown all these transactions and none of it was ever questioned, my lord. Suddenly now, because of the retrospective cancellation of the supplier, though he
So
has...
then should we just remand it back to the lower
Obliged,
authorities, and you may just produce the document and see, and will not express any view on merit of the
Obliged.
case?
Yes.
Counsel, what you have to say?
My lordship, first of all, this matter is not even required to be, re-adjudicated or represented in this forum for certain reasons which I would like to present here. And before that, if I can submit the written submissions.
This is more than 27 pages.
And not
No,
paginated.
my lord, it's only 12 pages written submission.
And not paginated.
It is paginated, and because some of the documents are already produced
Counsel,
by the appellant, I have
Table
not.
of contents where you have summarized some judgments, it seems. There onwards, I do not have a paginated document.
It's not paginated, yes.
Apologies, my lord, but I have those decisions in the virtual presentations. The physical copy contains only the written submission, and the court citations are paginated, and the proper indexation has also been made for the virtual.
What do you have to say about the documents that they've produced?
My lordship, first of all, I would like to re-clarify the issue which has been already presented.
First
by
address this question, and
Yes.
then you may
Yes,
please
my lord.
proceed.
So regarding the documentation is what is the question here. The documentations are already being produced by the appellant at the stage of ASMT itself, which is even before the proceedings have been initiated as per the Apex Court decision in the case of Armor Security. So the case, how it has been presented by the appellant is as if DGARM report is the only basis of this entire proceedings, and this is not the right presentation of the facts. The facts remains that the relied upon documents are not merely the DGARM report, but are also well backed up by the other evidences which are produced by the appellant themselves by participating in the ASMT proceedings.
So
And-
what do you have to say about those documents that have been produced in the ASMT proceedings?
Yes, the documents
The
which,
adequacy or inadequacy of that, can you please explain that to us, take us through that?
yes, my lord. So the documents which have been produced by the appellant are only the invoices, e-waybill, bank statement, whereas the appellant has in the entire proceedings, the appellant has nowhere produced the proof of delivery. The important issue here is the satisfaction of
Have you asked them the proof of delivery?
my lord.
There could be 10 other documents which they would not have produced. The question is, have you asked them?
Yes, my lord, because the fundamental issue itself is only under 16.2b and not under 16.2c, which means the question here is on proof of delivery of goods.
But e-way bills are there.
My lord,
Mentions
what does-
truck numbers? We
what
can
is-
see annexures. E-way bill sample copies are annexed.
What is 16.2b have to do with proof of delivery? Where do you read that in?
my lordship, this has been very clearly established by the Apex Court decision in the case of Ecom Gill, and which has also been.
That is not a GST decision.
Yes, my
is it?
lord, and that
Is
has
it a
been.
GST decision?
It is not in GST regime, whereas that has been already considered as a valid precedence in one of the Allahabad High Court decision, that Ecom Gill, very similar to how it has been.
But this bench of the tribunal, is it subjected to the High Court jurisdiction of Allahabad?
Agreed, my lord, but if there is no similar reference which is available in the jurisdictional High Court.
So then let's look at 16.2b which you are referring to.
Yes, my lord. So
And please satisfy us why proof of delivery is so important as you are insisting upon.
my lordship, this particular issue is specifically where there is an allegation not under any of the other vague conditions, but has been very precisely pointed on 16.2b, which is not only based on the DGRM report, but also when the tax officer has called upon for the documents to evidence the ITC conditions, the appellant is not in a position to provide any of these documents which would otherwise substantiate the bona fides of the delivery of goods. In fact, it is very surprising that today the learned counsel is trying to say that these documents can be submitted, whereas these documents have never been submitted, and in the entire proceedings, the principles of natural justice have never been violated, and hence what could have been evaluated at the adjudication stage cannot be entertained at the tribunal forum.
So tell us, counsel, one after another, all these important aspects. Number one, whether invoices were raised,
Invoice, yes, my lord.
GST paid.
GST paid is still an open question because the supplier is honest.
How would you say it's an open
Whether
question?
this were declared in GSTR 1 or 3B?
It is only declared in GSTR 1, and hence there is a mismatch, or rather there is no mismatch between 2A, 3B, and that is not at all a relevant point to consider here because the issue is only under clause B.
Whether e-way bills were generated in all the cases?
E-way bills were generated, however, that is not authenticating the delivery of goods.
Then why e-way bill concept was introduced by the government?
My
The
lordship,
only reason why the e-way bill was introduced to mention the lorry number, receipt number, goods, entire movement, and now you ignore e-way bills and ask again the LR copies will again go back to 20 years back. We have to proceed further. We need to have a progressive law.
Sorry,
I understand your this decision of Supreme Court, but there was no case of any e-way bill.
my lordship, however, the precedents have been already borrowed in some of the GST decisions as well, despite the e-way bill requirements. And I would also like to present one point here. This is exactly the manner in which these kind of fraudulent transactions are happening, wherein there are e-way bills. E-way bills are to authenticate if the movement happens, but the mere generation of e-way bill does not give a communication that the actual delivery of goods have happened. There are other conditions to be satisfied, and there are other documents to be prescribed, and that needs to be produced by the appellant, and the appellant has nowhere produced these documents until this stage, even though they have been time and again given the opportunity to produce these documents.
Counsel, can we read 16(2)(b)?
Yes, my lord.
My lord, it is in page 6 of the written submission.
Yes,
You can read it from the written
Yes,
submissions
yes,
from the other
yes,
side.
yes. So 16(2)(b) specifically states that, I start reading from 16(2), the subclause 2. Notwithstanding anything contained in this section, no registered person shall be entitled to the credit of any input tax in respect of any supply of goods or services or both to him, unless, clause B says, he has received the goods or services or both.
Full stop.
Yes, my lord.
The e-way bills exist.
E-way bills are generated.
You are disputing the e-way bills?
We are, my
Not on
lordship,
record, my
e-way bill is valid only during the movement of the goods.
And
Here the
therefore,
question here is-
therefore there was movement of goods. You acknowledge and accept that there was movement of goods.
My lordship, just because the
It is only as simple as a yes or a no. If there was an e-way bill which you are accepting and not disputing, then there was movement of goods.
my lordship, unfortunate
Counsel,
circumstance is
it
that
is not that difficult. Yes or no?
may not be, because e-way bill can
Alright.
still be generated without movement of goods. That is exactly what is the nation problem here.
Okay. So in that situation, did we take any steps to find out whether this appellant had actually received the goods? Was there an inspection carried out in the factory premises?
My lordship, all these have been already done. In fact, if you can see from
What
the
has
fact,
been done?
the supplier's traceability has been meticulously tried by the revenue side. It is not that
Counsel,
without
I am in a situation to decide as this bench the receipt of goods by the appellant, and therefore taking of credit and allowability of credit. Is that correct?
Yes, my lord.
So in that situation, when the supplier is absconding and is not traceable, how would that have a bearing on 16(2)(b) when the appellant should have received the goods?
My lordship, particular to this point, I would like to also insist upon that the burden of proof here actually rests on the appellant, and the appellant has.
So tell us, after they would have received the goods, what happened to the goods? They would have thereafter sold it.
Yes, my lord.
Or would have used
Are
it
they
in
a
their
trader?
manufacturing.
Are they a
And
trader?
there- is
They are
there any
traders.
output
Yes,
tax
my lord.
liability?
Yes,
you
my
have
lord. We have
discharged?
filed that GST3B, and that they have accepted. They have accepted all the tax remittances that have been made.
You
by us.
maintain a stock register?
Yes, my lord.
Whether that stock register was shared with the lower authorities at the time of audit observe.
No,
all
my
the
lord.
all the documents that were sought by them have been produced, my lord.
My
My lord, and
lordship,
if I may only
these
submit-
documents are
if-
never produced, and as I have already insisted, it is the burden of proof lies on the appellant, because the burden of proof from the department side has been already established, and now as per 155, the burden of proof rests only on the appellant.
They have not bought camphor which would have vanished in air, right?
No, in
There
Steel
is
scrap,
a
my lord.
purchase, there is a sale, they have recorded it.
Steel scrap,
What
my lord.
about the income tax? Both the parties' income tax, they have regarded it as a genuine transaction or not? That could also be one of the.
We have not
aspects we
faced
can-
any issue with income tax, my lord. Till now, we have not
Is
received
the
any,
assessment done? Any 143(3) notice?
nothing as of yet. my lord.
Counsel, how in other cases do you satisfy yourself about the receipt of goods?
Lordship, this has to be evidence along with the LR copy. If my lordship may permit, I
LR
would like to
copies-
draw reference from the Ecom Guild, which is clearly setting a direction as to what needs to be the document that has to be produced by the taxpayer to satisfy these conditions.
Why would we not be in a better position if the department was to institute a person there to sit and check the receipt of the goods?
That would be better. You will get a security officer.
Why
Lordship,
not-
that would
why
only
not-
add to the.
Why not this be a suggestion that goes to the GST Council, the board and everyone else?
Lordship, this would effectively mean we are going
how
back
is
to the
this
era.
tribunal supposed to sit down?
In every factory, they'll check what is
How
coming
is this tribunal supposed to sit down and adjudicate the receipt of goods, which is a matter of fact, and in respect of which fact there can be no evidence?
I understand, my lord. However, the one important point which I want to submit here is the appellant has been given opportunity from the day one to establish these proof with their evidences. And clearly, as I have mentioned, even as per the evidence law also, the burden is completely only on the appellant, and the appellant has not proven it beyond doubt.
My lord, if I
What
may only
proofs
submit.
they have submitted so far.
My lord, if I may only submit, even their reliance on Ecom Gill is entirely misplaced, my lord. In para 11 of Ecom Gill, which my lord will see in page 14, or it can even be projected here.
Yeah. Yes,
It
we
only
can state.
in the present case, the respective purchasing dealers have produced either invoices or payment of checks to claim ITC. Here they have not shown movement of goods, my lord. The assessing officer has doubted the genuineness of the transaction by giving cogent reasons on the basis of the evidence and material on record. In some the registration of selling dealers have been cancelled, or even the sale by the concerned dealers has been disputed or denied by the concerned dealers. In none of the cases, the concerned purchasing dealers have produced any further supporting material, such as furnishing the name and address of the selling dealer, details of the vehicles which have delivered the goods, payment of freight charges, acknowledgement of taking delivery of the goods, tax invoices, and payment particulars, etc. And therefore, it can be said that the concerned purchasing dealer failed to discharge the burden cast upon them under Section 70 of the KVAT Act 2003. In this case, my lord, each of our e-way bills gives all of these details in seriatim in all the transactions. They only require the name of the supply purchaser, my lord, and they have the supporting materials, that freight with the transportation details, etc., all of which is present. And not like my lordship rightly pointed out, they have not inspected any of our premises. They do not have a single document from our end to state that these were transactions that were not genuine.
You will consider all of the material that they have to provide to you in satisfaction of 16(2)(b) specifically. I think if that is the limited issue that we have, only in respect of 16(2)(b), they would provide you with the requirements that you pose to them, and please consider that and pass your order in 6 weeks.
My lordship, the only request, if I may resubmit here, is that this case does not warrant any re-adjudication, because whatever document that they wanted to submit, they have been already given the opportunity. By giving another round of opportunity, in fact, right from ASMT 10, they have been giving the same set of documents. They could have given any additional documents at an early point.
Those are the documents that we have, and all of them have been submitted before them.
You will have to satisfy as to how the goods were received and evidence it through all of these documents that we have discussed at this point, and to the satisfaction of, if they are able to convince, if you are able to convince them, then that should take care of it.
My lordship, however, this only adds to the administrative burden, because if the principles of natural justice are violated, if they have not been considered,
this document, it will add to our administrative burden. So let's remand it.
That is exactly my point as well, my lord.
We are pleased you make this point, because then we would make the suggestion, and if you like, we will record it in the order, that there would be better a person placed in the factory, in the warehouse, so that that inspection of receipt can happen on real-time basis.
My lordship, but these points they should have raised at the adjudication stage, coming to the appellate forum and then stating that the inspection has not happened at that point of time cannot be entertained here. This point has not been agitated as per the show cause notice responses in their appeal as well. And coming to the tribunal and engaging a senior counsel, trying to argue that the way in which the show cause notice adjudication has been conducted is wrong, is only trying to distract the focus of this court from the fulcrum of the issue. The fulcrum of the issue here is that there is a bogus transaction which has taken place without movement, without delivery of goods. The credit has been fraudulently availed. By effectively directing for a re-adjudication, we are communicating a different message to this kind of transactions which are happening at large in the society, which is not the right justice for the honest taxpayers as well.
My lord, if I may only submit, the appellant here has fulfilled all the requirements under law, my lord. Everything that was possible by them, they have fulfilled. They have produced all the documents that are required. But now, if the appellant has to ensure that the suppliers do not the suppliers properly maintain their premises elsewhere in other states, and the suppliers follow their legal compliances, and the supplier's IP address belong to the relevant network that is there. All that is not our work, my lord. The appellants cannot be fastened on a liability purely because of these kind of actions that are completely outside the purview of the appellant's possibility, and it's in fact an impossible task for the appellant to go against each and every supplier whose the trade cannot happen this way, my lord.
My
And
lordship.
GST has to promote trade.
Counsel, we will conclude this.
Yes,
We will
ma'am.
remand it
Yes,
for you to submit and for them to
Obliged.
consider and evaluate and then pass an order. And we would only leave you with this advice, not in our order, is that please consider all things that you would be able to provide them with to satisfy them
Obliged, ma'am.
about the receipt of the goods. Okay, including, if need be, FASTag related information, which will showcase that there was movement after that e-waybill was generated and it was not a bogus movement. Consider
My lord, the
even
only
such-
issue is looking at the assessment years being 2017 to 21. However far back we are able to trace those, we will definitely provide it, my lord.
Which
But
year we are referring to?
2017, 18 to 2020,
We are in
21.
2025.
2025.
Still within 8 years should not be a problem.
Yes, my lord.
You can't cite that as an excuse.
No, my lord, we'll try our best to
You
comply
are
with.
supposed
Yes,
to have 8 years record at least with you. So it's not 1990, right?
yes, my lord.
So whatever records you have got,
Obliged.
please submit that. We are just remanding this matter.
Oblige me.
Remand.
Obliged.
The last case for the day, GIL Industries Limited, Advocate Disha Jain for the appellate, CA Satyakumar for DR. I'm sorry, CA Satyakumar for the appellate and Disha Jain for DR.
My lords, in the last hearing, we had made the online submission of the return.
Counsel, first of all, how long you'll take, because we have
It's
to
a
sit
very
in the
short
larger bench
submission.
also.
My lord, it's a very short submission. My lord, this is the case.
Last time you argued virtually, is it?
Yes, my lord. And the matter was
This time-
adjourned.
and this time you've chosen to come physically.
Yes, my lord.
Why?
Lordship had instructed me to come physically, my lord, on an exception basis.
Let's proceed.
My lords, this is a case of solar power generator. The facts of the case is, I started paying GST 90% of the project value at project cost at 5% and 10% of the project cost, which is about 18%. And now the present issue is that the department has issued a circular in the year 2021 that is dated 6th October 2021. My lords, the circular number is 163/19/2021, applying a notification that was issued in 31st December 2018. That notification per se is actually prospective. This circular is retrospective, which is ultra vires that notification applies the ratio of 70-30, says that 70% should be paid at 5% and 30% of the project cost should be at 18%.
So do you want us to get this circular quashed?
My lord, the matter to be remanded back for two reasons. Not other than this issue.
Other request we are getting for a remand.
But the entire reason why it has to be remanded back, they have not mentioned under which section the DRC 01A has been issued. The primary issue here is about due process of law and the procedure prescribed by law. My lord, if you see Article 21 of the Constitution of India,
We are clear, Supreme Court also in Saral where it's quite clear.
my lord,
what we want to understand is not mentioning the section was detrimental to your interest. How?
my lord, that's where I go to the contours of the Constitution to just highlight what is the importance of the due process of law in the GST Act. My lords, the due process of law and the procedure prescribed by law is fundamental because it affects my personal liberty.
But
if you are not
Supreme Court says mere wrong mention or no mention of a particular provision does not violate the entire proceedings. So whether it was mentioned or not, you must simply state whether they invoke 73 or whether they invoke 74, and what is your submission in that connection?
My lord, the fact of this case, the department says that there is a tax evasion. When do they say there is a tax evasion? Only when there is a law. Here is a notification that was issued on 31st December 2018 applying it prospectively. And there is a circular that comes on 6th October 2021 applying it retrospectively. When there is no law, and circular is not a law as per Article 13 of the Constitution of India, just to highlight.
Why have you not challenged the circular in High Court? You have come here.
But I challenge this in the High Court. High Court has said the alternate remedy is there. Challenge section 73, 74 because the due process of law has not been followed. Well, section 74 requires the ingredient of mala-fide intention. And when there is a mala-fide intention, there is it amounts to criminal proceedings. And adding to that, my lord, just to highlight, in 2024, any evasion beyond 5 crores also attracts Enforcement Directorate proceedings under the Prevention of Money Laundering Act 2002. My lord, that is the reason the procedure prescribed by law is important, and highlighting the section number.
Is there any PMLA angle into it?
My lord, it has been notified as a predicate offence only in 2024. But
is this also subject matter of this dispute?
As of now, there is no proceedings under the Enforcement Directorate. But
why we are referring to it?
Because the importance of indicating the section number. When they start issuing the notice under DRC 01A, which is pre-intimation before the show cause notice has been issued, they should ideally frame the mind. The department should frame the mind under what section they are issuing. They cannot conveniently issue under section 73/74.
Council,
later take it up under 74.
Council, please clarify. They have not mentioned the provision in the DRC 01A or in the DRC 01.
It is under DRC, just a second, my lord.
Or DRC 07 for that matter.
Not, they have not mentioned it. Under
but Mr. Counsel,
DRC
we
01.
have never seen any proceedings which is under 73. All are under 74 only by default. So is this still
that is only
a matter of great consideration before us whether it is 73 or 74 or no mention? By default it is 74. Let's proceed on that basis.
As Lordship rightly said, department has taken a convenient stand now. Just because the timelines have crossed, they invoke section 74. There are multiple judgments to...
What my brother is saying is that the department invokes 74 in 99% of the cases. You should be well aware of that, and so presume that and proceed accordingly.
Let's proceed
that is the fact. I'm here to say that they cannot invoke conveniently. My lord, in the forms when they issue notice, they don't even mention 73 proceeding or 74. They conveniently mention 73/74 and then strike out 73 at the end. And now that affects my liberty.
But the law also allows that if a notice can be issued under 74 and then the appellate authority can convert it into 73.
But law nowhere mentions.
We should look at the next issue.
But this is first issue.
Proceed.
Second issue is with respect to applying 70/30 as of 1st July 2017. the question, the fundamental question here, nowhere in the law, it has been provided that 70-30 has to be applied on the day 1st July 2017. Now the department.
When you say that the notification is prospective, where do you draw that inference from?
Not notification number 24/2018. Lordship may refer to the notification in my written submission. My Lord, for a minute, my Lord, may refer to notification number. The scheme of this notification arises out of the 45th GST Council meeting, my Lord. In that, file number 190354/206/2021 TRU, under that, there is 11th item which talks about specified renewable energy projects. My Lord, that specified energy projects, they have provided, that industry has represented this matter of concern, where should I actually pay 18% on the entire contract, that is considering it as a works contract, or is there any proportion which can be arrived at? Based on this representation, the government has come out with notification number 24/2018, wherein it was made applicable prospectively. And further, an explanation was inserted in the said notification to say it has to be paid in 70-30. Now the department applies 70-30 and says whoever has taken 90-10 or 80-20, there will be a short payment of tax. That I will consider as a tax evasion. But with respect to those projects where the solar power projects have paid 18%, they have paid in excess.
Counsel,
when compared to 70-30.
Before you go there, why are you emphasizing that it is prospective?
But the notification says it's prospective. I will read out the notification. But I quote the exact words of the notification. Representation have been received seeking clarification regarding the GST rate applicable on solar PV power projects, specifically to solar PV power projects on or before 1st January 2019. The issue seems to have arisen in the context of notification so and so dated 31st December 2018. An explanation was inserted wide said notification that on specified renewable energy projects can be paid in terms of 70-30 respectively with effect from 1st January 2019. Notification is very clear, it is prospective.
This is the notification you were reading?
Yeah, I exactly read the notification, my Lord.
Okay.
The third line of the notification says January 2019. There comes a circular wherein the circular is 163/19/2021 to say this has to be retrospectively applied from 1st July 2017. In that case, the issue that arises here, I was paying under 90-10, 90% at 5%, 90.
Was that a scheme earlier, 90-10?
My lords?
Whether there was any such scheme, 90-10?
No such law, and it was supposed to be considered the works contract, but based on my business process, I know that 90% is goods and 10% is services. So I segregated conveniently to pay 90% to 5, but considering for the credit optimization.
So tell us, counsel, this notification was issued and you are mentioning it was issued based on the representation by the industry. You made the representation.
My lord, I was not part of the representation, my lord, just to highlight.
But it was part of from the industry only. There was a representation which was made. And what was asked that this particular issue has to be clarified. Why should not we consider this notification to be a clarificatory when it is based on a representation by the industry which is facing a particular issue of bifurcation, whether it should be 90-10 or 70-20 or 70-30 or 80-20, whatever that ratio be. Now since they have clarified it, it can be made applicable to the past period also. Why not?
Why not? Why I say it is not a clarificatory? Referring to the last line of the notification. My lord, last line of notification, you can see how department is looking at revenue is an important source, as we all know. But this line shows that department was not actually issuing a clarification. My lord, the last line says, however, it is specified that no refunds will be granted if GST already paid is more than the amount determined using this mechanism, let's assume I paid under 18%, I would have discharged more GST liability. Now applying 70-30, if there is a refund scenario, I will not be provided. Whereas if I had applied 90-10, now you apply 70-30, then in that case, I am considered as a short payment and they are issuing section 74. Ideally, section 74 proceedings will not apply on me.
Ultimately, 70-30 is a matter of concession. There are Supreme Court decisions that in matter of concession, there could be some conditions which might be attached. So if you accept the concession, be ready for the conditions attached.
My lord, nowhere I am saying that I will not accept the concession. All that I am saying is it cannot be applied retrospectively to affect my discharge of GST. Second, because of this fact, the circular is made retrospective. Circular is not binding on me in the first place. All that I am here is about the position of the circular.
What we want to understand is that there was some ambiguity as to how it should be taxed, and that is why representation was taken to the GST Council, which duly considered the matter, the topic, and based on inputs received from the industry, came up with this formula of 70-30, right? And we take it that from this date onwards, which is 1st of January 2019, there is no quarrel as to what is the taxable base and what is at 5% and what is at 18%. So the question is that if the industry rose up and asked for a clarity, why is it that that clarity is not to be seen as having always encompassed the period of GST from the word go, which is 1st of July 2017?
Well, even enacted laws, applying it retrospectively.
If you look at the circular also, that if you've paid, you've not paid previously, whatever may have been done, there is no refund to be allowed to you. In consequence, it in a way sort of indicates, maybe indirectly, that the 70-30 principle was always at the heart of it, was always on their mind. Maybe it was not brought out forth properly and in the formal notification.
But Lordship may know, here the circular not binding on me.
Counsel, let's talk about the notification. Circular we will deal with. We will have to address it separately, and we don't even need to address it because it doesn't bind us as well. But we are more interested in understanding why should that notification not have retroactive effect, effective 1st of July 2017?
Well, Lords, the notification was never retrospective. It is always prospective. If you see the notification, it is applicable from 1st January 2019 onwards.
That is your submission.
Well, the notification clearly says it is applicable from 1st January 2019. It is never applicable from 1st July 2017.
For all assessments that are undertaken from the 1st of January 2019, for the past period as well.
Is there any other case wherein this particular issue has been considered?
Well, there is no.
Or this is coming.
This is the first time the matter is coming up in this jurisdiction. We have also tried to refer to the other High Court cases as well. We don't find any precedents with this matter. Well, that's the entire reason that we are here.
So you are the only one who would have adopted this 90-10 situation. Others
my
are.
My lord, it is my business process. My humble submission. GST cannot enter my business and alter my business process. I am the master of my business process. They claim 90-10. Then I cannot ask why is the circular saying 70-30. So it is a business process, akin to business process.
You can ask. In fact, you can ask. Take this to the High Court and ask, why 70-30? Why not 65-35?
My lord, the entire.
Why not 60-40? And so on and so forth.
My lord, the entire.
One more representation.
Pardon, my lord.
Or make one more representation.
My lord, I am here put under section 74, rigor of 74.
In the next representation, just get it amended to 90-10 and let them again apply it retrospectively.
My lord, it is not easy to amend because it has to go through.
Your problem.
Well, as you know, my lord, it is not easy to get amended. It has to go through a mini parliament called GST Council, where state finance ministers has to come. Now the election time is also coming up, my lord. So accordingly, I am put under section 74 hurdle. So it is circular being binding on the department. It cannot be applied retrospectively. Accordingly, I cannot be brought under section 74, affecting the due process of law, wherein they should have mentioned under the respective pre-intimation show cause notice as well.
Counsel, if we are looking at this question on through the lens of section 73, what is the consequence?
Well, they will levy the demand, and interest and penalty may be applicable, and as such I have to
No, if it survives on 73 and not 74.
even under section 73 it does not survive.
No, I'm asking you, under the situation of 73, what of this demand will survive?
On the point of limitation, time limitation.
They have issued the pre-intimation show cause notice on within the time limit, my lord.
Simply just tell us, out of the entire demand, what is the demand which falls in the extended period under 74, and what percentage falls in the normal period, which is
Or
governed
everything
by
is in the
73,
normal period?
or everything.
My lord,
is
everything
the
is in
normal.
74.
So
Everything
there
is in
no
74.
portion which falls in 73.
Nothing falls in 73 because they started issuing 73/74. Finally, they decided this under 74, my lord. Accordingly, the matter has to be remanded back to see to that it is adjudicated.
Why not convert this to a 73
We
and
have the
adjudicate
power
it
to
accordingly?
convert.
Even then, this circular, making it applicable from the 1st July 2017, retrospectively, not being a law, makes this notice unlawful, this order unlawful.
Please elaborate.
My lord, even otherwise, if you take it under section 73 as well, as circular makes it retrospective. So as there is no law on that day, considering it, still this is unlawful. This order is unlawful.
Counsel, you're saying there's no law, but as we see it, one way of looking at it is to say that the notification is issued somewhere in 2018. It is made effective 1st of January 2019, which means that when the notice was issued, whether it's 73 or 74, assuming for a moment it was issued on 1st of April 2019 or 1st of April 2020. As it stood there, the law, and the notification requires you to apply it, the one approach to it is how we are saying is that all assessments, all adjudications which have to happen, have begun, whatever it is, will be with the lens of this notification, which is 70/30. That is what we are asking you to tell us. Why should it not be so?
But as there is no
Do
law,
you have any precedent from the apex court on the point that a notification can and cannot be read retrospectively?
my lord, maybe my lord, I will take necessary instructions in the next hearing. I will make the submissions, my lord. The lordship permits.
Okay.
Just read section 75 subsection 2, where any appellate authority or appellate tribunal or court concludes that the notice issued under subsection 1 of section 74 is not sustainable for the reason that the charges of fraud or any willful misstatement or suppression of fact to evade tax has not been established against the person to whom the notice was issued, the proper officer shall determine the tax payable by such person, deeming as if the notices were issued under subsection 1 of section 73. By virtue of this, mention, non-mention, 73, 74 is not that big a concern for the purpose of this proceeding.
Well, it's even otherwise, the law is not prevailing on 1st July 2017. I have adopted 9010 based on my business process, and I have discharged.
Let us come to the core issue. Why 9010? Why not 99-1? Why not 80-20? So what is the reason for 90-10? Do you have any kind of certificate which you would have taken from your cost accountant? Or is there any other, I don't know, chartered engineer certificate or any other basis, some historical data, some concrete basis to substantiate 90-10 as the ratio which has been adopted?
But all through, in my director's report, even the audit report, we have furnished this aspect even before GST came in. What is generally in a solar power project? What is our proportion of goods and services? Just for the convenience.
In that situation, why did you accept 70/30? It should have been immediately challenged.
But only when they issued.
We failed to understand that all along, all your director report, auditor report has been saying 90-10. And come a day when it says 70/30, and you silently and quietly accept it and apply it.
Well, that's because the notification said from 1st January 2019, you can take up a stand of 70-30 as management took a call that let's go for 70-30. So we still have a business decision which we can take.
Mr. Counsel, ultimately audit report, director reports, all these are matter of opinions. What we are asking from you is there any kind of certification? Is there any other concrete basis, some cogent way of establishing that 90-10 is an appropriate ratio?
For every solar power project, my lord, we have feasibility study. There is always an expert report.
Have you shared any such study material, any kind of report arising out of such study or certification with the department?
Yes, my lord.
And will they have commented anything on the same?
During the adjudication process, we did submit the reports to say in our business process it is 90-10 is the ratio, my lord. After considering only, they have passed this order.
You have a chartered engineer certificate, you have some cost accountant certificate. What is the nature
There's
of
a chartered engineer certificate who is an expert in the solar power project who had issued this certificate because that's a part of our
case?
project.
Who is that expert?
My lord, chartered engineer, my lord, who is...
Does he have a name?
He's a solar power project expert.
Counsel.
May it please the court, your lordship. I appear on behalf of the respondent. If I may take a few steps back and take your lordships through the genesis of how this adjudication order has come before you, I seek the permission to just get through the facts. So the genesis of the order, which is under challenge, stems from an investigation undertaken by the DGGI. Your lordship, statements were recorded from the customer as well as the appellant before your lordship to identify what is the or how they have come at 90-10. Your lordship, the investigation led to a finding on fact that this was a project whose cost was 400 crores. This 400 crores was arbitrarily divided into 90% for goods and 10% for services. Unlike a case where this is undertaken by two companies, this is a single company doing it. So a question arose among authorities as to why there is an artificial bifurcation when a single company is undertaking this project to the customer. This reason led us to further investigation to understand that the entire scheme was only a mechanism to evade tax. Like your lordship knows, under GST, the scheme is when a particular transaction qualifies as a supply and when there are both goods and services are involved. We go to section 7(1)(a) which tells us what would be the nature of this contract, specifically when there is a composite supply of both goods and services. And as your lordship knows, section 2(1)(19) deals with works contract, which in terms of schedule 2(6)(a) is a supply of service. Your lordship, the entire dispute spins around the fact of whether a composite EPC contract, which includes erection, procurement, commissioning up to the handover, would qualify as a works contract under GST. I would address the point on the circular as to why this is beneficial to the noticee, but your lordship, I seek permission to show as to how this would qualify as a works contract. For this, your lordship, I would just read the definition of a works contract under GST.
But is there any dispute whether it's works
your lordship,
contract or
as
not?
per the admissions made by the council,
They are also saying there is a service element and goods element, both are there. The only question is whether it should be 90-10 or it should be 70-30.
Your lordship, yes.
In both the cases, either it is 10 or 30. There is an element of service and goods both. So let's not get into what amounts to works contract.
Yes.
Let's come straight on the point why a circular can be applied for the prior period before the notification became effective. I feel that's the core issue here which needs to be seen. And if you have any material whereby their 90-10 ratio can be challenged and there are allegations that 90-10 is something which does not correspond to the actual goods and service ratio.
Your lordship, if I may answer that question in two folds, if we may assume for a moment that there is no 70-30, there is no 90-10, then the test before your lordship is what contract is this? If your lordship says with me that this is a works contract, then your lordship, the question is what is the rate which would be applicable? Your lordship, in such a situation, the entire 400 crore, the consideration would be subject to an 18% GST in terms of the services notification. Now, Your Lordship, the department, by giving the assessee a benefit of the circular, is actually not demanding tax at 18%, treating them as a works contract. Instead, siding with the industry, we are giving them the benefit to discharge GST at the 8.9%. We are giving them benefit of a circular, of a notification which was introduced later in view of the representations received from the industry for a previous period. So this is the reason why, Your Lordship, my learned seniors challenge to a notification or a circular being issued in 2021 being applied in 17-18 may be a little misconstrued, because we're allowing them benefit when the department has all rights to charge them.
Why the benevolence? Why aren't you asking for 18%? This
Your
is
Lordship,
government revenue we are talking about.
Your Lordship,
No,
Your Lordship,
you need to satisfy us. What is the reason for this benevolence?
Your Lordship, though my learned senior and Your Lordship, the circular is not binding on any of you. Unfortunately, it binds me. So I have to give them the benefit of the 8.9%.
That is fair. That is fair.
Much of it. So, Your Lordship, this is how I address as to why this. Your Lordship, with respect to non-mention of section 74 or 73 in DRC 1A, like Your Lordships pointed out, misquoting or non-quoting of a provision will not invalidate the proceedings per se. Here, Your Lordship, though this mistake was made in DRC 1A stage, in the subsequent show cause notice which was issued, all these points were clearly
Why
brought
can't
up.
you educate your officers?
Your Lordship, we are attempting to do that.
When will this attempt finish?
Your Lordship, I am newly appointed.
Every second case or by second, I would say 9 out of 10 matters which come to us in the SCN, what is written is 73/74 notice.
Your Lordship, I think this is the 10th case, because we have written 74 in the show cause notice are my instructions from the paper. So the 1A we have, Your Lordship, there has been an inadvertent error that there's a mention of a bar, but that has been rectified in our show cause notice where we have brought in. And Your Lordship, with respect to why section 74 has been initiated, Your Lordship, by this circular, an opportunity was given to the assessees to take benefit of 70/30 in case they had discharged a lower rate of tax. We have to consider that a lot of other assessees had discharged at 18%. By giving them that benevolence,
But if the other set of assessees have not had better wisdom and better advice and they discharged it at 18%, that cannot be the reason for their peril.
Lordship, fortunately today that is not the case. I would have to argue, but if I have to argue that, I would prepare in detail. The reason would be, Your Lordship, they would not satisfy the test of unjust enrichment, because they would have passed on the benefit.
No, we are not concerned with the others, and we are not even concerned with unjust enrichment. In this situation, there is a demand that you've posed, and you have been kind enough to let go of 18% on the whole and ask for it at 8.9%, as you mentioned.
Yes.
So now the question, and that's what you need to address and sort of clarify for us, is why should this notification be applied with effect from the 1st of July 2017, when you issued it and state within it that it's applicable from the 1st of January 2019?
Your Lordship, it's a very important question, because
That is the question. I
Yes.
don't, to my mind, there is no other question.
Yes.
If there is, please tell us.
No, no. The reason is because, Your Lordship, when we look at EPC contract, they are continuous supply of goods or services. So there is no rationale as to why it comes in effect on 1st January. The entire reason why 70/30 has been introduced is because there was a lot of litigation as to whether it will be 18% or 5%, which is not the case we are considering here. In order to put a quietus to such disputes or to adjudicate whether this is works contract or otherwise, this was introduced to settle, and it was based on a fair estimate of what goes in to make a solar power generating system. The concept of goods and services, a fair estimate was brought in, and the 31st GST Council meeting sheds better light on this point.
No, so if what you just submitted, that it was brought in to bring a quietus, I think there's a lot of things being done only for quietus purposes, but that's different thing. This was done for the purposes of settling the field and giving a uniform rate to be applied, and that there is no disputes of this kind that we are talking about, then it is quite logical that it would be applied going forward from the date it was introduced. Why and for what reason does this circular say that we will apply it with effect from 1st of July 2017?
Your Lordship, this is only to
You all have issued a circular, and now not forget, putting a quietus, you are going in the other direction.
No, Your Lordship, the reason why the circular, like one of the members mentioned, it is only a clarificatory nature. It is not imposing anybody to come and
So
pay.
therefore, what we then would take away from your submission is that this circular can be kept on the side, and we look at the notification in its plain and literal language, which very clearly says 1st of January 2019. Is that correct?
1st January 2019.
And if that is the situation, then your demand cannot stand.
Your Lordship, my demand would stand because the question would, again, as my show cause notice says, is it 18% or is it the rate which has been discharged by the appellant before you? Because there's a circular and because it binds me, Your Lordship, I have extended the benefit. If Your Lordship were to put aside the circular for a minute, then the revenue sidelines by getting 18% GST, Your Lordship, I will not come in the way because Your Lordship can very well hold that the circular does not bind you, but it binds me, Your Lordship.
My lords, just to highlight few points, my lords. Lordship permits for a minute.
2 minutes.
My lords, the notification number 24/2018 is notified under section 15 subsection 5. My lord, if you see 15 subsection 5, notwithstanding anything contained in subsection 1 or subsection 4, the value of such supplies as may be notified by the government on the recommendation of the council shall be determined in such manner as may be prescribed. This notification is for section 15 subsection 5. What is notified in the notification applies. Accordingly, only prospectively it applies. Now, circular coming in, that is issued by the department, cannot override the notification which is notified under section 15 subsection 5 under value of taxable supply. Apply it prospectively. Bring me under the short payment of tax. Issue section 74 notice without DIN.
Point, but still the question which remains to be addressed, that if this circular not to be applied, then why not you have to discharge 18% on the entire value? 90-10 prescription is nowhere there in the law. You cannot at your own end adopt any. Unless tomorrow you can say it's not 90-10, it's 199.
Unless council, you tell us that it's not a works contract.
My lord, it is a works contract wherein I have nowhere in the law it also says that I cannot do it under 90-10. Nowhere under the law it does say that I can't determine my business process.
Council, we'll need to get this correct. Please help us. It is a works contract. We are not disputing.
Certainly, my lord.
As the GST law is concerned, a works contract is classified as a service?
My lord, it comes under service and 18%, my lord.
Then you have answered.
My lord, but here my business process per se, I take the ratio of 90-10 and I'm able to segregate between goods and services. So I tax it at 90% at 5% and
power in your hand to segregate like this.
My lord, it's not the power, my lord, it's my business process. So GST cannot enter my business process and dictate saying what should be.
How many contracts did you sign? This 400 crore contract was housed in one single contract?
Whether the invoices were raised
This is the only contract in 17-18, my lord. There are multiple other contracts which I signed in 18-19 and from 19-20 onwards I have applied in 70-30.
The contract under consideration, which is 400 crores, is a solitary contract?
A single contract, my lord. A single solar power project.
Does it mention 90-10?
My lord, in our contract that we entered.
When we see the contract clause, it doesn't mention anything. It talks about a lump sum price to be paid based on the milestone.
My lord, if you see in the annexure, we have added saying it is 90-10, my lord. We have explained why it is 90-10 in the contract.
And have you raised invoices also separately?
Yes, my lord. We have raised invoices for that 400 crores, my lord.
Raise invoices separately?
Yes, we did raise separately. We did raise the invoice separately.
For goods separately and services
separately.
90
yes.
separately,
10 separately. And that is the reason it cannot be applied retrospectively. That's my humble submission.
Very well. So both the sides, please submit your written submission in 2 weeks, and we reserve this for all.
Much obliged.
Much
obliged, my lord. Can this submission be made in another 1 week, if the lordship permits? Much obliged.
We request CA Srikanth to hand over the memento to our counsel's advocate Jayalakshmi P and CA Sharda Hariharan. Jayalakshmi P, independent advocate specializing in indirect tax litigation, trademarks, family law, service matters and arbitration. Jayalakshmi. CA Sharda Hariharan, founder and designated partner at GCC Co., a highly recognized GST educator under GST with Sharda, delivering training to thousands of professionals and contributing to major ICA publications and industry platforms. Jayalakshmi P. Srikanth ma'am. Thank you, sir. We request CA Vishal to hand over the memento to our counsel's advocate, Dr. CA M. Satyakumar and advocate Disha Jain. A rare combination of advocate, CA, CMA. He represents clients before the Supreme Court, High Courts, tribunals and regulatory authorities across tax, financial and criminal law domains. A sought-after speaker at ICA overseas chapters, CIA, FICCI and global forums, regularly featured on international and national news channels. Disha Jain, advocate, practices before the Madras High Court with strong expertise in GST, customs, appeals, writs, advance rulings and departmental representations. Currently retainer counsel at Deloitte with prior roles at Lakshmi Kumaran and Sridharan and the chambers of Dr. Satish Prasaran, senior advocate. Thank you. I'll hand over the speaker to our chairperson, Revati Rao.
I request the presiding officers to kindly give mementos to our court master Vignesh and to our MCCA Shanmugapriya, who was also a counsel. And also mementos to the junior counsels who were kind of ragged by the presiding officers. Deepika and CA Deepika and Advocate Kritagnya. So, as these 2 days come to an end, it has been a very riveting 2 days for all of us, and GST was with its own share of actual what they had promised, courtroom drama and court craft. So I would like to place my appreciation to both the presiding officers who actually have given us a flavor of what is to be expected at the GSTAT. And I don't know, I'm not privy to the secrets if you are going to be elevated to the position of the GSTAT, but you have given us a flavor of this. No, I said I'm not privy to this, okay. And also to all the counsels who came and accepted and, had done their prep so well, and, you put your heart and soul into it, and you'll argue the cases and made it a little tough also for the presiding officers to do it. And also to all the chartered accountants and other advocates here who came here and made our day very very happy. We are very heartened at SIRC that such programs are being received very well by the members. And last again, thank you to Ravi sir for doing this, to the MC and to our office team. We had to put in a lot of effort to get this program curated, and so I want to place my appreciation to everyone who was a part of this team. Thank you very much.